Good afternoon, everyone. Welcome again to the ASC Standing Committee on Intellectual Property Rights and Biodiversity technical session. We have a long session today in the afternoon. So without further delay, may I invite our chair and co-chair. First, with Dr. Arvind Kapoor, the chair of ASC Standing Committee on Intellectual Property Rights and Biodiversity. He is also the managing director of Accent High Wedge. And next, Mr. François Bougou, CMA and co-chair of ASC Standing Committee on IPR and Biodiversity. So please.
Very good afternoon to all. I hope my voice is clear. Okay, thank you very much. We are going to have this session on intellectual property. I know that you have all sumptuous food, and it is our duty, myself and Francois, my co-chair, to keep you awake and give you the right content on the intellectual property. See, the IP is the only property which we all have, and we want to save it and get the value of it. We have some threat perceptions of losing it or not recovering the value of it. So today we are discussing many of these issues and try to debate that what is our right choice, that how we can do together. It is our responsibility as a seed sector that we should protect all together the intellectual property of each other and respect that. And that is how we can ward off the external threats of losing our IP positions. So today the program is quite big and heavy, and we have very good presenters today. And we are going to start this the presentations. So you, as you know, that we have the meeting of International Treaty on Plant Genetic Resources GB9 in India, and during this whole meeting for 7 days, we were engaged in different issues there, and where our sector is totally presenting its viewpoint, and we got some answers. We still have to debate many others. Still discussions are going on because all the members of the treaty, they have difference of opinion, and some of these outcomes will be presented today to you by Dr. Shvendra Singh, who will look into the different aspect and what is the outcome of this GB9 discussions. And then we will see that how we are moving forward and what we should do as together from Asia Pacific region, respond to those things and come together on a platform in the for the discussion in the next GB. So first I invite Mr. Shvendra Bajaj, Dr. Shvendra Bajaj. Dr. Shvendra Bajaj, you know that he is from the Federation of Seed Industry of India and Alliance for Agri Innovation as the ED. He normally engaged in all kind of stakeholder discussions and also with the center and the state governments about the advocacy role for the seed industry. And he's coordinating with all the members and bringing the issues, not only in terms of the positions and also in terms of the explanations to the government and to the other stakeholders about the IP positions. So Shivendra, he will present it today, the outcome of the GB9 in India.
Thank you, Dr. Kapoor, for the introduction. APSA has asked me to give the presentation just because I was part of this ISF delegation for the GB9 meeting. So I wish I was not part of it, but anyway. So I'm no way I'm expert. You have much more experts sitting in the audience. So, and of course in the panel there. So please forgive me if I misrepresent anything. And also I should say most of the slides, many of the slides have been from our colleagues from ISF and Zero Seeds. So if anything you contest, please contact them. Huh? So as Dr. Arvind was saying that ITPG-RFA meeting was held in Delhi, the GB9 meeting in September. And when Dr. May asked me to give the update, but I thought giving an update for GB9 as such is very difficult without understanding what access and benefit sharing is and what is ITPG-RFA, because I think that is more critical for people to understand. Things happen in a very small increments, if at all they happen in GB. So I thought I'll give you a brief background, and especially with special reference to DSI, the digital sequence information. So I'll give you a brief background about the access and benefit sharing, the treaty, especially with reference to DSI, and try to update what I understood from the GB9. So this is the overview of my presentation. So I'll give a brief introduction. What are the most relevant decision or the resolution? I should not say decision. Resolutions from GB9. What is the overall conclusion with DSI? And I'll try to answer any questions if you have. So before we jump into directly about ITPG-RFA, I guess we all know that there are two systems for access and benefit sharing. One is through the CBD, which is going to happen COP15 in Montreal next month. So one is through CBD, through Nagoya Protocol, which is purely bilateral, implemented by many governments right now. Even if they have signed a treaty on ITPG-RFA, still they use Nagoya Protocol as their tool for ABS. On the other hand, there is a treaty called the Intellectual Treaty of Plant Genetic Resource for Food and Agriculture that sits under the FAO of the UN. It's a multilateral system of genetic resources, and theoretically it should be accessible by one single contract. So in principle, it's quite simple, but in practice, it's much more challenging. Through one contract called the Standard Material Transfer Agreement, or SMTA. And I'm sorry, I'll use a lot of acronyms here, and I'll try to make sure that I'm able to at least expand those at least once. So for the seed sector, I hope I can say that the ITPG-RFA treaty is the most preferred tool for us to administer the ABS, and that's why I put in general. The treaty itself entered into force in 2004. 138 countries and European Union are the contracting parties. Very significantly, also some of the countries, especially in our Asia Pacific region, are not the member of the ITPG-RFA, which means that they have to go to the CBD Nagoya Protocol for any ABS systems. In fact, Thailand is not a member of ITPG-RFA as well. So coming to the ITPG-RFA, it's all driven by a body called the governing body, or the GB. It's a decision-making body. As I said, it's consists of 149 parties. The decision taken by the GB is through resolution based on consensus or the lack of consensus. And it can be, I would say, I know Anka is shaking her head, it's mostly lack of consensus, I would say. It's attended, can be attended by observers, like, many of our seed sector are represented as observers, ISF and other seed organizations. It occurs every second year, usually, if I'm correct, once in Rome in FA and once in other countries. So as I said, that it's governed through theoretically one contract, the SMTA, that came into effect in 2007. So SMTA has established the terms for the access under the MLS, and what is MLS is called multilateral system. It has defined conditions for monetary benefit sharing. The payments are basically 1.1% minus 30%, that's comes out to 0.76% of your gross sales. If it is under patents and other conditions, otherwise it's a voluntary payment. So the main thrust for the seed sector as such is the enhancement of this multilateral system. So multilateral system, as I said, is a specialized access and benefit sharing instrument of the treaty. Its scope is mentioned in Annexure 1, and I'll tell what Annexure 1 crops are. It started in GB5. However, there has been always a complaint that there's not enough money coming to the benefit sharing fund through this provisions of the SMTA. So which means that it has to be enhanced. And then, several years they've worked on the enhancement. The 2019, the governing body 8 meeting, it came to an abrupt halt because of the reasons which I will discuss later. So far there has not been any agreement on the payment rates. And DSI, the digital sequence information, is one of the key factors for this deadlock. However, between the GB8 and GB9, either because of COVID or because of the deadlock it was happened in GB8, most of the consultations were informal through online meetings and all. So so one thing about the enhancement of ML is to expand the scope of the Annexure 1. So in Annexure 1, there are crops listed, which are 64 crop listed. 35 of them are food crops and then forage crops. However, most of the vegetable crops are not listed in Annexure 1, except for, I believe, eggplant is listed. But others like tomato, chili, these crops are not there. Capsicum is not there. So obviously there has been discussions to expand the Annexure 1 crop, Annexure 1 of the MLS to all the crops. And there has been always a discussion about the benefit sharing fund, how to increase the money flow, and discussions have been happening for several years, and there has not been any consensus or agreement between the countries. Some says we have to increase the rate, others says you have to increase the scope of the treaty, scope of the Annexure 1, expand it, or it could be both, or expand to include digital sequence information, which will be also discussed at a bigger level in the CBD. So with this background, I'd like to talk about what happened or did not happen in the GB9. That was in Delhi from 19 to 24 September this year. And there were some informal sessions prior to that. So ISF as seed sector, we were represented there in Delhi. As I said, that objectives for us, the objective of the treaty is very relevant to us for the seed sector, because the seed sector prefers the ABS through this treaty. But also seed sector, it's important that seed sector is present, although we do not have much say. We have, maybe 3 or 4 lines during the whole 7 days to say, but I think it's always important to be there to give inputs to your national delegates. So it's always good to have a broad representation of the seed sector there. So one thing is about, I just said about the enhancement of the MLS. So in governing body 8 meeting in 2019, the negotiations kind of failed. However, the informal meeting still occurred. Some countries were really skeptical to start, and that's what happened in GB9. To restart in GB9, however, the resolution, as I said, the decisions are based on the resolutions, and you can go to the TT website to get all the resolutions. Now they all are in place. So the resolutions are already printed there and online. So I have borrowed from the TT website. So they decided to set up a new RTAG, and RTAG is Ad Hoc Technical Expert Group. So again, economy which is to be co-chaired by Australia and India. The scope of this RTAG is to work on the revision of SMTA, expansion of Annex 1 crops to all crops probably. And they will have one meeting before the governing body meeting, governing body 10 meeting happens in Rome next year. So usually it happens every 2 years, but because of COVID, there was a gap of 3 years from 19 to 20. The group has been requested to pay special attention to what's happening on DSI. In fact, and I will tell later, they do not agree on the term as such. So they use DSI/GSD, which is genetic sequence data. Also work on payment rates, and they have to prepare a checkpoint report to GB10. And seed industry has 2 seats in the expert group, although many can attend as backbenchers to listen to it. So other important point is about the funding strategy, and I think eventually it's about, as Arvind was saying, about protecting the IP and sharing of IP, and eventually it all comes down to the funds and the benefit what they get. So in theory, I mean, what we want is a system to enhance the availability and transparency for the provision under this treaty. But new funding strategy has been adopted for the period for next 5 years in 2019. And I mean, I think you can read that this is literally verbatim that the funding strategy supports implementation by achieving of particular SDGs there. So the GB has established a very lofty target of about $1 billion per year as a collection that they would achieve from the exchange of the genetic resources. And of course, they are a little bit practical that nothing can be achieved very much next year. So they set up a target of 40% by year 2026. And so it has also be aimed at the financing is available at different levels, at national level where TT is key, as well as generate fundings from different other mechanisms, including the benefit sharing fund as well. So the committee is to develop a methodology, which is, I think, one of the significant, we can call it achievements of GB, was to develop a methodology for measuring non-monetary benefit sharing, because seed sector has been very vocal that the non-monetary benefit has to be included as overall in the funding strategy, because seed sector as such has been contributing a lot on the capacity building and other measures, the kind of investment they do in the country. So that could be part, that should be part of future negotiations. We FSI made a small contribution to the benefit sharing fund. The idea was not about the money, but the idea was to show the intention and support of Indian seed industry towards the benefit sharing fund. And also, I think it's also kind of significant to urge other governments, and I think we believe it's not just the developed countries, but also developing countries should also contribute. It's not like it should not be one way. So I think our intention was to sort of highlight this point, and also the GB was happening in Delhi, so it was a more appropriate moment too. So this was what has happened so far in the GB9 meeting. I'll talk briefly about the digital sequence information. So if GB meetings are not complex enough, DSI, inclusion of DSI further adds, I would say, flavor to the complexity in the discussions, because not many of us, if at all of us, understand what DSI exactly is. So there has been different viewpoints, and I really try to simplify this by not including many complexities here. Some says that just a nucleoside sequence data, the DNA, RNA should be part of it. Others says the entire protein. Some says the entire cassette has to be taken as DSI. So again, it's as I said, there is no clear definition, no clear agreement on DSI as of yet. It was raised in GB7 by the African region when the meeting happened there in 2017, I believe. And that was one of the main reasons for the failure of GB8. So now the DSI or the digital sequence information has been used as a placeholder in the international discussions. As I said, that definition is not very clear. So if the definition is not clear, then the scope is also not very clear. So right now, it could be a narrow scope, or it will be broader scope. It could be just a DNA, RNA, or you include all the metabolites that you generate from DNA and RNA as such, or anything in between the two as well. So, but why to apply DSI? And it's always good to understand the views of other parties to really, if you want to solve a problem. So, why to apply ABS regulations on DSI? So, one thing which I deliberately did not say in my earlier part is that the treaty discussions currently applies only to physical access of genetic resources, which means that the digital sequence, and that's what the critic says, that it's not included in the benefit sharing if at all that happens. Which means that, and some argue, including in our country in India, many argue that as more and more R&D has been done, more industries become more scientifically advanced, they may not need access of physical like seed or germplasm. They can, they can construct a gene using the online genetic digital sequence that is available in online genetic databases. So thereby bypassing the access and benefit sharing mechanism of the legislation. So this could be also a political response that, okay, so if that is the case, although I do not know how long that will take to not access physical resource and do everything online, through the digital database, but the political response was to, okay, then why not apply ABS to DSI as well? That should solve every problem. But that has created more problem because we don't know what DSI exactly is at the moment. But having said that, DSI of the last few years has taken a bigger center stage. Now it's part of post-2020 global biodiversity framework. It has set targets, and DSI is very much part of it. Developing countries really want to have a benefit sharing based on DSI as well. The developed countries want to have a deal on DSI. So that's the deadlock kind of thing. But why is it all relevant? So first of all, it's relevant because, as I said, that under the treaty, only the physical access of genetic resources is covered. The second thing is, when I showed the introductory slide, that not all the genetic resource is covered under this treaty at the moment, which means, Annex 164 crops. Beyond that, you have to go through Nagoya Protocol, the access and benefit sharing. And breeders also use other genetic resources, not only the seeds. Like, if you want to develop a disease resistance, you access pathogens, you access weeds for developing weed resistance and all. So for them, DSI is relevant because that will, also give result which are generated by the breeders, and basically to speed up the breeding process. And then, DSI, people say, can be accessed from public databases also, as compared to other sequences. But what are the challenges for having DSI included in the discussion on ABS? First of all, it's at the moment, I don't know if we're able to resolve very soon, that it's impossible to know what is the value of it, contribution of DSI in the new commercial variety, how much sequence someone used to develop a new variety. It could be a lot, it could be nothing. And it's impossible to track how the information was used. But breeders definitely use that, and they should be free to use the information. And some says that downloads have been done this much, but that doesn't mean those downloads have resulted in usage, or they're actually being used. And then if the user has to pay for access and benefit sharing, which eventually could mean that even although the database right now are free to use, but it may not be free to use in future. And then it has to be under a contract. And it could have a lot of implications. Many of the researchers for their research work, for their thesis and all, they use Access database, you blast search and all, which means that even the researchers may have to pay for their work as well. But DSI is not going to go away. I mean, I think that we have a clear realization. In fact, it's going to be there in many forums, more noticeably in the CBD, upcoming CBD. It will be there in the treaty, and now it's part of many other discussion forums. DSI has been part of it. So coming back to the GB9, now DSI is now formally part of discussion. As I said, when I was saying about the enhancement of MLS, although the governing body 9 has not, or the GB has not yet finalized the official name or terminology, what do you use? So they said that you should use as DSI/GSG until a new terminology has been agreed, which we don't know when it will be done. Which also, as I said, that they will continue to monitor developments in other international fora and then report to GB10, and also encourage parties at the CBD for potential solution to be fair and equitable, and also mutually supportive. It's not like there should be a new mechanism altogether. So which means that the co-chairs of enhancement of MLS will also report on any progress on DSI to the GB10 body. Capacity building and sharing of experiences is one thing that has been added, which means that everyone agrees that there is not enough capacity to understand what DSI is, and we should continue to work together on development of capacity on DSI. So overall, what happened in GB9? In fact, these are the 3-4 resolutions. I did not talk about farmers' rights because I know Francois is there to talk about farmers' rights. So I just, I kept out of my presentation. Overall, the trend is that in the GBs, the attitude of countries towards seed sector, it's a broad statement, not a very specific reference to anyone. It's not very positive. Although the NGOs are very active and it's increasing. As I said, the resumption of MLS, which stopped in Rome in 2019, is a positive step. Having to clarify what exactly DSI definition is also a positive step, I would say. That at least they realize that they need to define what DSI is. And then now I think all the discussion, especially on DSI, focus shifts on COP15 that happened in December in Montreal. So that's my presentation. If I can answer any question, I'm happy to. Thank you.
Thank you, Shivendra. Thank you for real explanation of the GB9 output. As you know that we have issues there to discuss, and few answers were there and few answers were not there, and a lot of discussions happened. So I think based on these outcomes, which we have seen either expansion of the Annex 1 or looking after the corpus fund. So everything was how to create a fund which can conserve the biodiversity. So many issues are related to those because DSI, if it's included for benefit sharing, it will part of the, again, corpus to be created. So based on that, do you have any question? Because we have some time for few questions. If you want to know something more or any clarification from Shivendra.
Okay.
I think everything is well understood, that what we can do and what we can't. Thank you very much.
Thank you. Thank you so much.
Yeah. So now we move on to the panel discussion. And I think we are going to have so before they set up the stage for the panel discussion. Okay. So let us start with the first the response of the panelists. They will get 15 minutes each, and this panel is for the access and benefit sharing. Whether this is a facilitated mechanism or obstructive mechanism. So we put a very challenging topic, that what they think is that this will facilitate access, and correspondingly we get the benefit sharing out of it. So there are two components, so they will discuss about it. So our first presenter is Mr. Ashwini Kumar, who's ex-Joint Secretary Seeds, Department of Agriculture and Farmer Welfare, Ministry of Agriculture, Government of India. He has 32 years wide-ranging experience as a civil servant in various ministries, including agriculture, shipping, higher education, labor, employment, cabinet secretariat, defense, and commerce. And he tried to have a very noticeable contribution in all these areas of administration and development. And he also was chairman and managing director of National Seed Corporation, a public sector undertaking. He worked in as a joint secretary in Ministry of Agriculture and Farmer Welfare, Government of India for more than 7 years. And his focal point was to forming the national policy for seed sector, and played a very notifying role in that. And also his major contribution is that he was the main organizer of the GB9 of the treaty in Delhi, and it's very successfully concluded there. And all the countries and the participants were really appreciative that they like the GB9, the way it is conducted and way it is supported by Government of India. Sir, Mr. Ashwini Kumar, please.
Thank you, Dr. Kapoor. Good afternoon to all. The small presentation is there, and this is my own personal view. It is not an official view. I will just like to say. So this is a presentation on access benefit sharing on germ plant. So what is the access benefit sharing mechanism? Facilitated or obstructive is the question has been put by Dr. Arvind Kapoor. So we have got an access, we have got a benefit sharing, and there is genesis of two laws, CBD and ITPG RFA. and they can provide the insight into the discussion. We need to discuss ABS. It was discussed in 9GB also. Main is the access with the bilateral or multilateral. And then the research work for it is access is there, and the commercial access is there, which is monetary and non-monetary. So we have got a convention on biological diversity, objective rational, conservation, sustainable, facilitated access, benefit sharing on all biological resources, and environmental degradation and climate change due to our exploitation of the biological resource. We are concerned also on the biopiracy and unequitable distribution sharing of the benefits, provides for bilaterally agreed benefit sharing with providers for the resources. Sorry. So CBD has ABS is under bilateral agreement, which is as per the international accepted standards, require prior informed consent and the mutually agreed to terms. That implies it is a facilitative process for access and benefit sharing. IT-PGRA, there is a conservation and sustainable use of PGFRA. Context food and nutrition security of the world. Multilateral system is there for the exchanging genetic resource. Pools of genetic resources available, and benefit of commercial use or deposit to the TT fund used for the multiple sharing. In IT-PGRA, the access is multiple source and mainly PGRFA and the food feed used for the agriculture crops, not it is access for the all crop. And benefit sharing, however, is as per applicable rates already defined in the SMTA. India is a part of the TT and to develop the new crop varieties and a climate resilient varieties and ensure food and nutritional security. Crop sizes and the wild relatives originated in different parts of the world. Therefore, the countries are interdependent on access of the germplasm. Before CBD, germplasm was accessible freely to everyone. Now the sovereign rights are exercised. Governance of germplasm of crop is done as per the IT-PGRFA. India has developed a gene bank, national gene bank, where 1482,000 races are capped. CGIR centers are there. They are also making 805 races are there. Others are having around 55,000 races. So these are a lot of gene bank races are stored in the country. And we are the second world largest gene bank in our country. In the 9GB meeting, the questions were raised for the capacity building and resource for the development of the new gene bank, and certain CGRA also has requested that some funding should be there, which was accepted in the 9GB. The material access from the MLS by India, there are several countries on several crops, they have accessed the material. Now the enhancement of the functioning of the MLS in GB8 Rome, governing body could not reach any consensus, and formal intercession process on MLS enhancement was suspended, which was again restarted in the GB9. GB increased informal consultation among the contractive party and especially national consultation among sectors and relevant stakeholders. Informal consultations on the MLS Switzerland proposal was there, and it helps in the increased benefit, increase user-based income to the benefit sharing fund, expand the crop and plant genetic diversity available, as Mr. Shivendra has said, that we have to increase the list of the Annexure 1, make the MLS more dynamic, development and emerging issues of science, innovation and plant breeding, create legal certainty and administrative simplicity for everyone participating in the system. The important issue is the DSI, which was also discussed in the 9GB also. It was discussed in CBD also. Unlike plant TT, CBD has continued the deliberation and the open-ended working group which in November 21, and suggested a multi-criteria performance matrix to assess the various policy options on DSI. It is very important to understand DSI issues and solutions that are being deliberated and further on CBD to prepare a TT discussions. India supports the technical deliberation must continue to provide clarity on definition, scope, jurisdiction, and nature of implementation and ABS system, ABS mechanism. TT should not wait for the CBD. It was a view that TT should continue for the discussion on the DSI issue and resolve it by deliberation. So both CBD and ITPGRA provisions and the processes are facilitative for ABS related use for the resources. However, these provisions are for the tangible resource only. The intangible resource were not there at the time of when the TT were formed, and so non-tangible resource related to the biological resource, that is genetic sequencing information or data or digital sequence data. These international instruments were not prepared in the context at the time they were put in place. So now access to the non-tangible resource is multilateral, therefore somewhat untraceable origin. But benefit sharing is expected, as was the context of CBD, unequitable benefit sharing. Biopiracy still is one of the apprehension is there. In the context of the benefit sharing, apprehension of unequitable sharing of the benefit due to wide gaps are still exist. Advanced technologies available with the developed countries and potential resource available with developing countries. Sharing of exemplars to comply with the national regulations is affected by the complex ABS and has negative impact on research and development. I just also want to add 2 slides on the farmer rights, because farmer is also important in the benefit sharing. In India, we have got a Protection of Plant Varieties and Farmer Rights Act 2001, which provides the farmer rights. The farmer has a right to save, use, sow, re-sow, exchange, share, or sell his farm produce, including seed of the variety, protected under Plant Breeders' Right. I just want to give a slight clarification. It is only the sharing. Not, he cannot sell it anything with a commercial level. Recognize farmer for conservation of native traditional plants and rewards from the gene fund. We give the reward of 10 lakhs rupees for the 5 farmers, and 10 farmers we give the small award on the gene fund, from the gene fund. Participated as a member of the authority, farmer has a right. We have got 2 members from the farmers in the authority in a board. Article 9 of the ITPGRA includes all these subjects to the national laws under Article 9 of the ITPGRA, which recognize the farmer contribution in conserving and developing plant varieties and traditional knowledge, the right to equitable participation in sharing benefit, the right to participate in making decision at the national level, and right to save, use, exchange, and sell farm save seed and propagating material. No other country's legislation include the right to save, use, or re-sow, exchange, share, and sell the seed. No other country recognize the traditional land disease of varieties as practicable and make these public domain material accessible by anyone. I have, as a JS seed, I have made around about 3,000 varieties, mostly in the rice, where there are the traditional varieties and which is still conserved by the farmers in the country. This is the same slide where we say that it supports the legal framework, possible option of the implementation of the farmer right to all contracting parties, support and facilitation of initiative by contracting party, and conduct of a background study. So this was the issue which was raised in the GB9, that we should provide the fund to the developing countries so that they can develop a mechanism for the farmer rights, and they can study the things, how they can give the benefit to the farmer rights. India has proposed for the global symposium, which was accepted and which is there in GB10 in 2023. What need to do further? We have to establish an MLS intersessional group with a new mandate and revised terms of reference, and that build up lessons learned from the previous processes. Group to be more inclusive by regional balance, including all stakeholders, open-ended so that any contacted party may attend, and support by robust regional consultation. SMTA revision, both single access as well as subscription system to be a part of revised SMTA, and public institutions, farmers and small seed companies may be excluded for any payment and all those things. As in India, farmers are not charged anything for the registrations of the farmers' variety. In other hand, the government gives the support to them to have a registration of their varieties. The possible solutions are there in the context, contribute specific scientific advancement, transparent and inclusive access processes. When access is seemingly untraceable, benefit are still untraceable. Wider sharing of technology as a non-monetary benefit to be explored. These are the few points which I feel that it should be done in a transparent way so that more access can be given. I think Mr. Savindra Bajaj has raised the issue that India is not willing to have the DSI. So I feel that India is support the DSI, but it should be proper defined and have a transparent mechanism. And whatever the benefit anybody gets, that benefit can be shared properly in a transparent way so that everyone is benefit from that. Thank you very much. Any questions?
Yeah, thank you, Ashwin Kumar ji. We will have a round table discussion and then we have the questions to you. Thank you very much. Thank you for raising and explaining different issues in that because we have time issues. So we'll move to the next presentation. Next presentation by Dr. Lorna from Agriculture Center, National Crop Research Development and Production Support System, Bureau of Plant Industry, Philippines. And about her, she is serving the government as a researcher and administration for almost 35 years. And she obtained the doctorate in bioscience engineering from the KUL, Belgium. Currently, she is Agriculture Center Chief of Bureau of Plant Industry, Devio National Crop Research Development and Production Sports Center. So she's also serving as Assistant Director and also involved in the ITP-JRFA from Philippines. So please, Dr. Lorna.
Okay. So good afternoon. I will be presenting some of the views from the Philippine side, although generally these are already supporting the discussions that was presented by the first presenter. So our topic is on the access and benefit sharing, facilitated or obstructive. So we were asked, what does access mean? We will say that access means that we can provide information on the available materials available in the MLS through an SMTA. That's how we would get it from the ITP-JRFA. SMTAs, which is the mechanism, need to be signed between the seed bank and the seed company. In relation to the Philippine laws, access is only allowed upon compliance with the following domestic laws. So we have about a few. We have this joint Department of Environment, Natural Resources, Department of Agriculture, law and guidelines for bioprospecting activities in the Philippines, laws on the Wildlife Act, Indigenous Peoples' Rights, Another for the Indigenous Peoples Act also. We have laws on the seeds, the different laws on Traditional Medicine Act, the Magna Carta for small farmers, which actually includes the farmers' rights and other relevant laws. You can see that aside from the ITPGRFA guidelines, we have to consider all these domestic laws in order that access can be made from the Philippines. Now, if we go to the DSI issue, which has been actually explained, as elaborated, DSI is still undefined or not fully defined. And we have been looking into the CBD for the definition. But for the Philippines, together with developing countries, we support the revision of the definition of PGRFA to include any digital sequence information derived directly from genetic materials accessed through the MLS. So we have to include, when we say the ITPGRFA, it should include DSI. I am just answering all those relevant questions, guide questions that were provided to us. So let us go to if the mechanism can facilitate or obstruct the use of genetic resources. If we follow the ITPGRFA, the mechanism was established to facilitate access and share benefits from their use following Article 10.2, which is really good. And the contracting parties actually established this MLS for efficient, effective, and transparent, both to facilitate access to PGRFA and to share in a fair and equitable way the benefits arising from the utilization of these resources on a complementary and mutually reinforcing basis for Annex 1 crops. However, as discussed by the previous speakers, access has been made, but unfortunately, the benefit sharing part is still not seen. The benefit sharing that developing countries or countries that have been availed of come from the donations from developed countries, but not really from the access users. Now, if you look into the question if ABS supports DSI, the ABS supports DSI since access can be considered a benefit to the user country. If a country which gets the material and which can access the material, it will also benefit because from the genetic information, it can potentially produce different varieties. So we propose to include the genetic sequence data derived directly from the PGRFA from the MLS as part of the information. So the proposed definition would be any material of plant origin, including reproductive and vegetative propagating materials containing functional units of heredity, including genetic sequence data. That's why it would really, we have been really supporting that we cannot expand even the MLS if we cannot really define what DSI means. Going back to what the benefit should be, it should be monetary and non-monetary. As per GB9, the rates are still not negotiated, and actually it has not really been further discussed. but hopefully this would really have a clear target and should be transparent. The benefit sharing should be to support conservation of BGFA, especially on farm conservation in developing countries. For seed companies, we suggest to follow possible measures to encourage natural and legal persons to include their materials in the MLS, or place a sample of their product that incorporates the material into a collection that is part of the MLS for research and breeding. And also, seed companies need to meet their social responsibility to equitably share benefits arising from the use of the genetic resources, as indicated in the DSI. Thank you very much. Salamat.
Thank you, Dr. Lorna. I think it's a very crisp and focused presentation, answering to the best all the questions. So we'll discuss further on the round table. So our next presenter is Mr. Hotano. Mr. Hotano is Deputy Director, Global Environment Affairs Office for MDRI, Sustainable Food System Strategic Division, Minister Secretariat, Ministry of Agriculture and Forestry Fisheries, Japan. Mr. Hotano is in charge of domestic and international affairs related to biodiversity and utilization of genetic resources at the Ministry of Agriculture, Forestry and Fisheries, Japan. Prior to current position, he served more than 4 years as a project coordinator in ASEAN Secretariat, managing, implementing public-private partnership, capacity building project on the food industry and agriculture sector in ASEAN country. He was also assistant professor at Nagoya University and arrived at Yangon University for 2 years as visiting faculty. Dr. Hotano.
Thank you very much, and good afternoon, everyone. And thank you very much for giving me a very good opportunity to speak on the very important topic. The title of the panel discussion is on the access and benefit sharing facilitated mechanism or obstructive mechanisms. But what is important thing is that there digital sequence information as a speaker has already explained. So I will focus on this very important topic on digital sequencing information in the some international fora like Commission on Biological Diversity and the ITPGRFA. So in my presentation, as Dr. Shubhendra said, the DSA is still a placeholder word, and personally and our governmental view is that the genetic sequence data, GSD, is better and appropriate word for this purpose. So in this presentation, I will use a DSI word for easy understanding of the presentation. So we are in the turning point in our international discussions. Now we finished our governing body 9 session of international authority in September, and we are just before the timing of the CBD COP10, which will be held in December. And after that, maybe next year, we will have a working group on MLS enhancement process. And also, we will see the next governing body of international authority. And COP11 will be held in 2024, and the next governing body will be 2025. So we will many processes in these 2 or 3 years on digital sequence information. So we need to ensure balance in these related fora. So in each process, so many countries is looking for outcome. The most updated and big issue will be the post-2020 global biodiversity framework. this will be adapted in the COP 15 and in next month. And at the same time, some outcome of the SI will be adopted the same time. So this is a combined issue sometimes, but we think that it will be separated, and we need a separate discussion because this is very sensitive issue. So I need to explain about the prospect for the international discussion. So we need a solution that is simple and take into account the circumstances of industry. And also the legal certainty is very important in this context. So what is important things is that the discussion and the final decision on genetic resources on food and agriculture should be able to make in specialized fora such as international authority and also some others related fora like CGRFA. And the final discussion decision on DSI should not be made in the CBD. So there's a different fora about the CBD, so also many of the participants is from the authority of the environment. So very small presence of agriculture authorities and seed stakeholders. So I will monitor your next month, but I will see very little agriculture or seed related stakeholders. This is very a big issue for us. So in the ITPG Alpha, so flexible and consistent solution can be considered with special public interest and conveniences for stakeholders. The very limited stakeholder can have a good outcome with a proper discussion. This is very important. So I will explain about the outcome on the MRS enhancement at the International Authority on GB9. So Dr. Shuvendra has already made a very precise explanation on GB9. So this is the brief playback on his presentation, but we think that GB9 is a process, and this process is still going on in the next year and 2 years, and after 2 years. The GB established the ad hoc open-ended working group on MRS enhancement. And in its meeting, the process should build on previous progresses and achievement, both in terms of structure and content. And the working group co-chaired looks to structure the process so as to accord our attention to key issues such as DSI, payment rate, and other relevant aspects, and provide the checkpoint reports to GB10 on progress and for any further guidance regarding the continuation of the progress. What is important things is a checkpoint at GB10. So we need to see the situation of the discussion of CBD COP 15 and also the discussion in the working group of MRS enhancement process, and whether we will go on the process of MRS enhancement in good condition. So we will see this condition in GB10. This is the meaning of checkpoint. So we will discuss in 2023, and we need to see the balance of discussion and see the situation of trust building of member countries. What is a good solution to the DSA problem? So there actually is so many problems and so many points to care, but I will explain the very few points on from these many issues. The first thing is that no one size fits all regulatory framework for DSI. So different sector will see different impact from the use and the regulation of genetic resources. A second point is that no restriction should be placed on access to and the use of DSI. So there are many burdens associated with the establishment of new regulatory framework. Some people say that we need a new mechanism on DSI, but so in that case, we need a new governmental system or new legal system. So we need to see we need to know the situation and how it will be burden for government and industries and stakeholders. And the third point is that no traceability should be made mandatory for the use of DSI. Traceability is not desirable in terms of facilitating research and development, and also from the cost perspective. And in this regard, the public disclosure of the use of genetic information is very problematic in our view. So there still are many points we need to discuss. But what is important thing is that the harmonized implementation of the multiple areas instrument is needed. And actually, in the discussion of DSI, some people mentioned that we should seek the solution of the decoupling system, which decouples the access and benefit sharing. So in that case, it may be the out of scope of ABS system, but in that case, the same we also need the proper clarification and similar care for the systems. The DSI on the genetic resources for food and agriculture has generated many public benefits. So we need to take into account many benefits from these genetic resources. It contributes on the problem of increase in the global population and projected economic growth in developed countries, and the chronic malnutrition in the developing countries, and increasing weather abnormality. So there is a big concern on global strains in the balance of food supply and demand. So we need to promote sustainable agricultural production activities. From this perspective, we are seeking solution to these situations by using DSI. So we need very colorful discussion and observation for DSI. So now I will explain the discussion in the CBD. In CBD, we will have a COP15 in next month, but before COP15, we had an informal advisory group meeting to discuss about the policy option for benefit sharing on DSI. And also we had several working groups. And just before the COP15, we also have a working group for 3 days to discuss about the DSI and the post-2020 GBL. In CBD, there are many very positive arguments for the establishing of the multilateral mechanism. Actually, there's a proposal that the global multilateral benefit sharing mechanism in CBD, and some negotiator, some delegation proposing that 1% levy on biological related product is very needed. And some other delegations and countries requested to discuss on the hybrid solution. This hybrid means a bilateral mechanism and the multilateral mechanism. Some countries already introduced their bilateral mechanism for benefit sharing on the DSI. So in that case, they want to have a bilateral and multilateral hybrid solution. So many believe that bilateral solution is problematic. However, many countries have already introduced a national mechanism for benefit sharing on DSI, but this is a very complicated problem for current discussion. So the landing point of COP15 is still unclear. However, we should not jump into a hasty solution. So there's still no good and balanced solution. So we need to step-by-step approach for seeking the good solution. This is the Japanese view, and I will explain this view in 3 slides, but there's a problem of time. for presentation. So you can see the Japanese point of view from the website of ITPGRFA homepages. So that what is important thing is the open access to DSI is very important. And no additional cumbersome obligation should be imposed to analyze the objective of the international authority and the MRS, and cost benefit analysis is very important. So please see the Japanese viewpoint from the website of the ITPGRFA. You can see another opinion from member countries by international authority, and the ISF is also updated their position in here. Regarding the DSI, some region has their own view, in my opinion. So some region is seeking monetary benefit from developed countries. This is the main point of their discussion on DSI, as far as I know. And another region is that seeking complicated hybrid solution system. So regarding the Asia and Pacific region, so we are in a little bit different position. We think that we need a more deliberated, more consolidation is needed for the discussion of DSI and for seeking a solution on DSI. So when we had a open-ended working group of CBD in Geneva in March this year, we had a regional statement on DSI. In this statement, we said DSI at this stage, the region requested that the decision may be taken after due consideration. So there are many views, but the Asian region has one voice on this point. There are different views in many countries in Asian region, but this point is so more consultation and more deliberation is needed for this issue. This is our position. What is required in the next step? So actually, we need voices more and more from agriculture and the seed industry. So very few agriculture authorities participated in CBD negotiation, actually. So nevertheless, CBDs make decisions that affect the agriculture sector. So the voice of food and agriculture sector, of course, including the seed industry, should be properly recognized by the CBD delegations in each country. So in my point of view, the Asian seed industry can unite in seeking a proper understanding of the international situation and what considered outcome for appropriate solution for the industry. Actually, regarding the business and the biodiversity, there is an ongoing discussion on the assessment of business dependency on biodiversity. There, from these international fora, the position and the contribution of industry is coming more and more important. So input from seed, food, and agriculture sectors into environment negotiation is expected to become even more important in the future. So we need to aim for a long-term benefit for all government, stakeholders, and all participants. So what is important things is that the improved functioning of ITPGRFA by expanding the crops covered by the Annex 1. So we discussed this point in the GB9 in New Delhi, and in my understanding, there is a little participant who has an objection on this point. So this is I think we can unite in this point in Asian regions. And the solution to be considered for DSI in a way that is less burdensome for the seed industry. and a solution with proper consideration of plant genetic resources for food and agriculture in respective forums, including the CBD and ITPGRFA. And actually, there is another forum like BBNJ. BBNJ is a biodiversity beyond the national jurisdiction. In this forum, they are going to adopt a new treaty, which is one part of them dealing with genetic resources, especially in marine area. And we are seeking for solutions that aim to increase all benefits in the long term, rather than aiming for short-term benefit sharing. And we need a step-by-step approach based on stakeholder input, and this is a very important point. So we need to gather voice from every related stakeholder for further discussion on this topic. Thank you for your listening, and let's find the best solution for the industry. Thank you.
Thank you, Dr. Hatano. I think very clear presentation and very clear viewpoint of Japan about different complex issues. So I think now we will have the question, answers, and roundtable of all the presenters. Yeah, please, all the presenters now can come to the stage. Yes. Yeah, thank you for waiting for preparing the dice. So now you have listened to all the presenters, their viewpoints, country viewpoints, and in terms of also the treaty and what is the position globally happening. So now we have the discussion points. So the first question to the to Mr. Ashwini Kumar, if you see the pre-CBD era, a lot of germplasm was exchanged before when the plant breeding started. And we have seen the development of agriculture and also food production in the world. So if we say that at that time, if access was free and contribution happened significantly at that time, what was now made changes in terms of sovereignty of the country about germplasm, which really have gone positive way rather than the obstructive way, because many breeders think that if they need any material, they can well go to the scientists to develop the material, or gene where the gene banks are there, where the hotspots are there. So what is make the difference between the two? if we see the development pre-CBD era, because we have seen the green revolution in India, for a lot of germplasm came from the CG system, and we got a lot of food production. And in the post CBD, what changes do you think gone positive, and what changes gone negative?
Thank you, Mr. Kapoor. At the pre-CBD time, lot of germplasm was exchanged, and the developing countries have given lot of effort for giving the germplasm. And once the new variety comes, then lot of trade charges is taken back by the company. That has come to the issue that the benefit sharing should also be there. If the company is taking a benefit by developing, putting effort and developing a variety, but at the same time, the germplasm which resource has been taken from the country or from the any farmer, that should be passed on as a benefit sharing. Lot of talk has been done for enhancing the annexure 1 or making the 64 crops in annexure 1, but benefit sharing has not moved very much faster as the germplasm resource is transferred much faster. That's why there was a reason the TT has come, and the TT has put up the word of the benefit sharing, and still the benefit sharing is not done much ahead at present. That is the issue. Thank you.
So the major issue now is that access was facilitated by the multilateral systems, where we know that we have still 64 crops, and many countries are still not exchanging germplasm under the system. And so-called there are negative lists are created now. What are the basis of those negative lists, and why they are being created, and what will the benefit country will get out of it?
Each country which has got a specialized crop, which is grown in that country only, and if any research work is going on by taking those germplasm, still again the formula comes for the benefit sharing. The company which is taking or the developing the variety with taking the resource, they have to share it, the benefit sharing. Because once the new variety is introduced in any country, they take the trade value, they take the benefit from that, but the benefit is not passed on the country where the germplasm has been taken. So those countries, if the germplasm, they can even think of it, is my view, don't quote it as a country's view. If at least in that country they can introduce the variety with the free of trade value. We have tried certain things to be introduced in the country, but there was so much hindrance for the trade value that this should be there, then only it can be introduced. So until you take care of the country from where the resource is taken, it will be very difficult for those countries which are developing to give the resource to them, and then taking those variety back to the country and paying for that in a higher price. Thank you.
Thank you. I move to Dr. Hadano. You see this what we call germplasm, the gene pool is like currency. If it is not in circulation, it is a dead currency. You can't do anything with that. But if it is exchanged and used, it creates a lot of benefit for the society in terms of developing varieties, in terms of developing disease-resistant material. So the benefit is accrued through the variety developed for that country, and the production which will happen provide food, which is a big benefit to the country if it's a food. So what do you think that why we do all kind of restrictions when the benefit accrued after using the currency, and then this currency is multiplied in terms of the production, food production, and providing food to the populations?
Yep, that is very a difficult question, and so I think that we need a balance of interest and the actual situation of each industry and each stakeholders, and so the benefit should be expanded more. This is a position of some countries in the ITPCR fair and as a further, but so we are now still going on the process of the financial related strategy in the RT-PCR affair. And firstly, we need to access it to related industry and ask their understanding on the relationship with the genetic resources, of course, including the DSI. And so we need more detailed communication and derivation on these issues.
So what you are saying is that, if today what we are seeing is access and benefit sharing, in that benefit sharing, if I access material today, it will take me 7 to 8 years to develop a variety. And I will pay when the variety go to the commercial sale, and then I start paying the benefit. Do you think this mechanism is at presently not working, not providing sufficient resources for the conservation? And that's what treaty is discussing. What is the alternate mechanism you think which will provide year after year money for the conservation to the treaty or the country, so that it is a continuous process where conservation and development happen for the not only the excess of germplasm, also benefit to the people who are conserving, or to the gene bank who are conserving? What do you think about the mechanism which we have present, or what changes you are looking for?
Yeah, the current system is still in the process of reinforcing, and it takes 3 or 4 years, and we need to discuss more detail in the future processes. But the current system, in my point of view, is not enough for the conservation, and also the good appropriate and other facilitation of the system of the international authorities. So in any way, we need to discuss more how to reinforce and how to enforce, how to find a better mechanism.
You have in your presentation mentioned about DSI very in detail. What do you think that, this discussion on the DSI or GSD to be included in the benefit sharing, when a lot of open access information is there, and this will help breeders to create varieties, in a very open system. And present, the plant genetic resource is defined as a physical material to be exchanged. Nowhere PGR is mentioning virtual PGR, which is, we call it DSI. So what do you think that, I saw Japan position is very clear, that DSI should be at present discussed in detail and should not hinder any process of multilateral system expansion or benefit sharing?
Yeah. Yes, this is closer linked to the actual materials utilization. So we need to find a solution to cover the DSI situation in the current system. This is our position. So from this perspective, so we still have so many problems, including there's no definition on DSI. So we need to find a fundamental solution for these issues. And after that, we need to find a good way how to cover the DSI in our system. So actually, I think that in the GB8 in 2019, we are coming a very good solution, but the negotiation was stopped and for 3 years after the GB8. So we will start it again, the process, and we will find a similar solution. And in this process, we need to have a discussion on the DSI also.
Yeah, thank you, because I know that it is a long process and long way to go. Dr. Loreno, you have a very focused presentation. What do you think that with the present system of the treaty of multilateral, which is being used at present, what Philippine position is that, they want to expand the Annex 1 in all the crops should be in multilateral system where all breeders can be benefited through the present system of SMTA?
The Philippine position is that we do not support the expansion of MLS at this point until we can see that the benefit sharing is already in a way tangible for all those countries that have given their resources, especially for developing countries. Especially now that the PGR does not only include only the physical genetic material, but also for us, it should include DSI. For the Philippines, it should also include DSI.
So you think that you are looking for only bilateral exchange and not the multilateral exchange?
We do support the multilateral exchange as we are a contracting party of ITPGRFA, but hopefully the SMTA would also be revised to really cater to the benefit sharing part, that it should really be felt, because it's the only the access mechanism is the only one that is being felt at this time. But we do at the moment we are doing more of the bilateral exchanges.
So that means the treaty, which is having the corpus, and they are providing funds for the conservation under the project mode. So Philippines is not interested to participate there as a conservation projects.
The Philippines is interested to participate, but for several years, we only have a few researches funded by the benefit sharing, and it's not really being felt by the different gene banks in our country. Also, maybe it's the rice, like the IRI, that has really been also getting some support, because we have also placed the rice varieties in the MLS.
Yeah, well, CG system, they have the mandate
Yeah.
to share the germplasm with the contributing countries. So Philippines got the benefit out of the International Research Institute.
Yeah.
Okay.
But for the national gene banks, we really haven't felt the benefit sharing funds.
So now for the audience, you have any question? Yes, Enke.
Good afternoon. My name is Anke van den Hurk. I'm working at the Dutch Seed Association Planten. And I have a question for Mrs. Lorena. With regards to your point that you said access is all settled already. It's all easy, and yeah, the benefit sharing is not coming. And I'm a bit confused, to be honest. You say that the access is already organized, but when you explained access to the Philippines, I thought, whoa, that is a hard task to get access to materials from the Philippines, because you said you used the SMTA and there were some like 11 other laws. So could you explain, please, if I come as a breeder to your country, what steps I have to do to get the access? Because then we can make the benefit sharing arrangements. But yeah, if the access is not settled, then I don't know how to do the benefit sharing. Can you clarify? Thanks.
So it is question to you, Rano, that if some breeder comes to the Philippines and want to access the germplasm, what step they should follow? And what is the benefit sharing there in terms of when a breeder do get material from the Philippines as a bilateral system?
As of this time, we still follow the SMTA being used in the ITP-GRFA. Although the IRR, the implementing rules and regulations actually, has really still not been in place in Congress. So it's more of country really negotiation of what if we really can give the material that you want to access. But at this time, the only materials that we have declared is for rice and taro and some for bananas.
Any other question? Yeah, please. Mike.
Good afternoon, Mark Cool with Corteva AgriScience, a US-based but globally operating research and investment company in seeds. And just on the topic of DSI, I'm actually rather confused because I, as a breeder, cannot understand how I would take genetic information from a book or a piece of paper or a computer and use that to create a variety. I don't understand that connection between the virtual resource and the real material. What I can understand is what happens very frequently and successfully is using the information developed by people before to give me an idea of the value of the genetic sequence and therefore accessing that through the plant material and then using that in my breeding program. And wouldn't that access point of the physical material be the right trigger to then start an access and benefit sharing system rather than the information that guides me, rather the access itself? So my question is maybe to help me understand what the value of the information is without access to the genetic resource itself. Thank you.
So the question is that how to value the sequence information when a breeder uses the genetic material. How we can know or how we can use that because during his breeding he used the sequence information. He accessed germplasm. He used the sequence information to do breeding and use the breeding methodologies. So what is how this can happen in future when the discussions happen on the DSI? How to value it? How to put it in the benefit sharing system? The whole sequence information. Yeah, please, Patano. I think you had the clarity about it.
Yes, thank you very much for a very good question. Actually, the value of genetic DSI, genetic sequence information, these are sequence information. This is very problematic issues. So from the perspective of Japan, so we are the part of the mechanism of INSDC. This is a very big public database constructed by the three pairs, Japan and the United States and the European countries. And from my understanding, the non-monetary benefit sharing by using this kind of public database is also included in the value of DSI. So just not the benefit sharing by DSI this is not the good way of thinking. So we need to see the overall condition, increasing non-monetary benefit sharing and database utilization. And the value of DSI is different for each industry and each stakeholders. So some company will use the DSI for more direct path for their benefit. For instance, some medical companies will use a DSI for more direct way to produce some vaccines, like recent developed technology such as messenger RNA. But in the field of seed industry and the plant genetic resources related industries, the situation is more simple, and the user this in more simple way, not so industrialized way. So we need to evaluate each way of using for industry and what kind of value is happen in each stakeholders. This is I think important point.
So Mark, have you got the answer? Not yet. Yeah, I think better.
Yeah, well, thank you for that. My point really was that breeders very actively use genetic information available from previous researchers that gives them an idea of how the genetic information could be used in a program. So it's a guide, it's a signpost. It shows them where they might be able to access a gene sequence that codes for a characteristic of a variety which they're interested in. So there's a lot of value there, but the actual physical capturing of the value only happens when you access that gene sequence, insert it into a variety, and then bring the variety into your breeding program. And in the seed industry, we very, very much support the concept that at that point, an access and benefit sharing mechanism should be triggered. And if there is an origin of the genetic resource, the material, the plant material, we agree that there should be a benefit sharing back to that original source country. But the information itself, by itself, has no value. I can't create a new variety just by reading a book. I can read the book and say, oh, this material has potential value for me. Let me go and try to find it, bring that into my program, see if the value is in my final variety, and then would be able to share a benefit back to the original source country. But the information itself, I have a very difficult time understanding how you can try to capture a value of that, because it is just a sign, it's just a goal, it's just a way to understand where you would look for value.
No, you are right, Mark, that these are very complex. I don't know, because we started from pre to CBD laws, then CBD to treaty, and now we are moving to DSI. I think that is what we say, that whether we are moving more towards the facilitation part of it and making the life of breeders simple, or we are moving towards the more complex structures where we have to really do all kind of things to create a evaluation of benefits. We don't know what level of benefits we will create. I think my panelists will agree that systems are complex. Every country is looking into differently. Every company is looking differently. Every administrator is looking differently. And maybe globally, everything is very differently. So once again, if there is no question, thank you very much, panelists. I think you have done your job? Yeah.
Yes, I have two questions. One is for Mr. Kumar is the fact that you said that the governing body decided to engage the discussion regarding the benefit sharing fund with a target for the benefit sharing fund of 1 billion. And we know all very well that the last proposal at GB8 of a seed industry, which was close to 50 or 60 million, even that it was a reason to stop in a way, because we had no agreement. And 1 billion is around 2% of the turnover of a seed industry. And in a field crop, self-pollinated crop, 2% of the turnover is quite 100% of the profit. So it will be no more benefit sharing, it will be benefit keeping, which can be acceptable by the seed industry. So I'm afraid, and I want to have your opinion on that, that if we start a new discussion with this objective, we may be sure that we will not succeed again. And my second question is for Dr. Eradura. You said access is working, but benefit sharing is not working. It means that for you, access is not a benefit. And here again, we have, I think, a strong disagreement between you or Philippines regarding that and the seed industry. Because for us, access in itself is a strong benefit for everybody. And not only, if you look, it's not a benefit for multinational companies of developed countries. If you look at the SMTAs, the multilateral system is more used by developing countries than by developed countries, and more by public research of developing countries. So I want to know why for you access is not important.
Yeah, for clarification, it's access is a benefit for the user, but for the provider, for some developing countries that has given the resources, benefits has not been felt. So it's I would like to qualify on that access is a benefit itself for the user, but for the provider, especially for developing countries, it has not been felt greatly in some ways, maybe. But for all those millions of materials that has been accessed or shared in the MLS, you said that a small percentage has only been placed in the benefit sharing fund. So that's what is my clarification. Access and benefit can be access can be seen as a benefit for some, but not for all that has not really benefited from it. So I am just qualifying on that statement.
Regarding, you have said that 2%, 1 billion will be the requirement for the ITPGRA for the benefit sharing fund. I still say it is from the last 20 years, the TT has come and we are struggling for the benefit sharing. So we should come forward to have a discussion, have a norms in a transparent way, so that whatever the benefit you can share it, that can be gone to the treaty. There are a lot of resources which are present in the country. The gene bank has to be made, and for the developing countries, especially for the South America and South African countries and some Asian countries, it is very difficult to sustain that genetic resource which is preserved in their country. Though we have got the second largest gene bank, but other countries also need some benefit so that they can support the genetic resource available in their country. I still say in India, still a lot of resource is not stored in the gene bank, and lot of work has to be taken to get whatever the genetic resource is there in the country to be brought to the gene bank. So benefit sharing is very important, and it should come in a transparent way from all the agencies or the countries where the benefit is taken by having a new variety and selling it to the world. I do agree we need to make some revolutions for the better food security, but still at the same time, we have to also see that whatever the germ plant is there in the developing countries, they should be also protected and preserved there. And the benefit of restoring or keeping those should be passed on to them. Thank you.
No, I think also what we discussed in the GB9 that we have to tap other resources like food industry. So I think the onus should not be on the seed industry only. There are further down the stream, this variety is used for the processing industry. Maybe a specific traits, they are available to them. If they also contribute, I think the target of 1 billion can be met. But I think don't expect that only the seed industry should cater to this whole benefit. I think the treaty has to look into other avenues from other resources so that all stakeholders should be involved, because we are keeping public sector and farmers and other people who are using resources also out of it. So I think maybe in many other areas where the other activities like if the social responsibility fund, which is with the industry using, can be used for the conservation. I think multiple system can be created, not only depending on the seed industry to contribute for everything. So I think if there is no question at present, so thank you very much for the panelists. Thanks a lot for your contribution. Yeah, thanks a lot. Thank you. Thank you. So coffee break. So I think in this session, more or less what we said, that whether it is a facilitative mechanism or obstructive mechanism, I think we are in between. So we are in between still. We don't know whether the whole system which we created or being discussed will move towards more facilitation or will create more obstruction. It all depends upon the future. We know the long path from GB9 to GB11. I think GB11 will see that whether we move to Annex 1 expansion or more clarity on the DSI, because CBD is going to discuss in these 2 years on the DSI, whether it will have impact on the treaty or whether we'll sail through the CBD explanation. We don't know yet. But I think we as industry, we should continuously educate, bring more information in the system itself, so that we put our viewpoint very strongly, as mentioned by Mark and Enke, that we should continuously say that what breeders' need is, whether this makes sense to us to bring DSI into the benefit sharing, or whether the system of subscription which we talk about as industry, that we really voluntarily contribute every year based on the agreements, and we use germplasm freely, and then we give, and from other resources, treaty can get the funds. So thank you very much for participating. Now we have the coffee break for 30 minutes. No, reduced to 20 minutes. 20 minutes, please come, and there is a very important session after that, because we are discussing some of the very important issues in the second part of our session. So please come after 20 minutes. You will hear more things from the IP perspective. Thank you. Welcome back after the coffee break. So now we are going to another area of our IP issues. As you know that there are in the treaty, in the different laws, there is a mention of farmers' rights and the breeders' rights. Farmers' rights and breeders' rights are well explained in the ITPGRFA. But I think what we say as a seed industry, that farmer has a right to get good seed. Farmer has a right to get quality seed. Farmer has a right to get performing seeds. That is what the right farmer is looking into. I think farmer is not looking into that he will try to save the seed. And there are many indicators which we have seen in the countries and globally, that farmer is not taking risk for saving few pennies for the seed and wasting his 90% of the efforts of growing crops. So there are different explanations and there are different discussions that farmer has the right. Yes, farmer has the right who can maintaining certain gene pools. Yes, he has the right to conserve it. He has the right to take the benefit out of it. We are ready to give to the farmer the benefit. But farmer has also right to get from us. He is expecting from us to provide good seed, quality seed for his crop growth. Based on that, we will start this session. And the first speaker is my co-chair, Mr. Francois, who will explain us the interrelationship between farmers' rights and breeders' rights on the private and non-commercial use of protected varieties, which is now being under discussion with the UPO and other organizations. Please, Francois.
Okay. Thank you very much, Arvin, and thanks to all. My presentation will be maybe a little surprising for you because of the title, but the title is more the title of the discussion we need to have in the afternoon. After myself, we will have the point of view of a farmers organization, and after that, we may have some discussion. But I think that before to be fully engaged in that debate regarding interrelations between farmers' rights and breeders' rights, we need to go back to easy things in a way. The first one, easy things, it's the Human Rights Declaration, because at the end of the day, we have a lot of debate about is it normal for breeders to have rights and so on? And yes, the answer is yes. All the countries, or mainly all the countries of the world, are saying, yes, we are in favor of a human declaration, a universal human declaration of rights. And in the article 27.2, it's clear. Everyone has the right to the protection of a moral and material interest resulting from any scientific, literary, or artistic production of which he is the author. So why there would be only one thing which escaped to these rights, the seeds? There is no reason. Anyway, it's true that the plant breeders' rights were the last intellectual property rights at the international level. They were created in 1961. It was, as I said, the last one. And very few countries still in APAC have rights for breeders. It means we are in a region where it's more interesting to be a singer because you have rights for 50, 70 years than to be a breeder. Even if to write a song, to be honest, even if I like very much music, you may write in 5 minutes if you are very, very good. And it's impossible for a very, very good breeder to create a new variety in 5 minutes. So this is the base. Secondly, excuse me. Yes. More than half of the population of the world are living in our area in APAC region. And a majority of the people, of the part of this population is directly or indirectly engaged in agriculture. Secondly, this population is projected to increase from 250 millions from now to 2030. And we heard yesterday morning the representative of the Ministry of Agriculture of Thailand who said that we consider generally that 450 million of smallholder farmers in the region are producing 80% of the food consumption. So when you look at these figures, it's clear that what is clear? Yeah, it's clear that we need to create some relation between creation of new varieties, innovation, increase of the production of agriculture, and the fact, so breeder remuneration at the end, and the fact that we need to address these smallholder farmers. It's why we had a lot of discussion in APSA from the beginning of APSA when we start the association. Because we had many occasions, and especially when we discuss about the position papers of APSA regarding intellectual property rights, because at the beginning of APSA, it was not a lot of countries, even many seed associations, were not so convinced about the interest of intellectual property rights and plant variety protection. So, but we are convinced from the beginning that we need to have innovative breeding and research to have this capacity to nourish the population of the region. Secondly, it's why the relation between breeders' remuneration and access of these smallholder farmers to new varieties and good seeds is a concern of APSA since our start. So, in the last position paper of APSA, and I encourage you, if you don't know this position paper, to go to our website to look at it, because as I said, it's the result of more than 2 years of discussion. We said clearly that we recognize the 91 UPOV Convention as the best system for plant variety protection. And we recognize, don't say too much on this, we recognize UPOV 91 as the best system of plant variety protection, of course, because of the breeder's exemption. And I had no time in our first session, but when the lady, she's no more here, it's, I'm sorry for that, of Philippines said, we encourage breeders to put their varieties in the multilateral system. In a way, it's strange. It's more difficult to have access to new varieties in the multilateral system than with a breeder's exemption. With a breeder's exemption, you have nothing to sign to have access for breeding and research to varieties. With a multilateral system, you need to sign an SMTA. So anyway, breeding exemption is the core value of plant breeders' rights. It's why APSA supports the plant breeders' rights. But it's also because of the farmers' exemption. You have two exemptions which are targeting the farmers in the UPOV Convention. The first one was at the beginning of UPOV, 71, 78. It's the one regarding subsistence farming. It means that when you are a farmer with no commercial activities and you are using new varieties only for your own food, the family, the food of your family, you may use protected varieties. You may produce for you protected varieties without any payment to the breeders. So it means that the question to say, yes, but the farmers, why they have to pay? No, and especially the poor farmers and so on. The poor farmers have nothing to pay if we are in the scope of a plant variety protection of UPOV. The second one, which was a lot debated, it's about farm-safe seeds. It was a lot debated even in the international treaty, even in Asia and in other regions, because the first convention, the first act in 71, 78 of the UPOV Convention, 61, excuse me, 78, never talk about the production by farmers and the use by farmers of protected varieties. The fact that they never talk doesn't mean that it was always possible. I may give you the example of my country in France. it was totally forbidden regarding the 78 convention that we applied in France. It was totally forbidden for farmers to make any farm safe seeds because the government of France at that time and the parliament decided that it has to be forbidden. At the end of the day, my feeling, it was not a mistake on that time because the industry, the seed industry in France is still strong today. I think it's not by chance, but because we ensure this remuneration of breeders and breeding activity. But you had two phenomena. First, in France, sorry, in France, you had farmers' organization in France who said, if finally, if it's forbidden for us to make farm safe seed, it's unfair because it's a tradition and we may do economy which are not linked only to the royalties, but also to the production of seeds and so on. So you had this pressure on a part, and on the second part, you had countries who said, yes, it's totally free. For example, you may take UK. It was totally free to make farm safe seeds, but at the end of the day, there was no money back for the breeders. So these two pressure were going to the 91 convention. And in the 91 convention, we had an optional exemption on farm safe seeds, and we said that it's possible for government to create an exemption for farmers to produce their own seeds and on their own farm and for their own usage, if they are given some remuneration to the breeders. And we have to say clearly, after that, it depends on the countries. You know, there is a balance between the freedom you want to give to the farmers to use farm safe seeds and what I said at the beginning, the fact that you need some money back for breeding activities and for breeders. It doesn't matter if these breeders are public or private. Breeding is a long activity and breeding has to be funded. And we know very well that, especially in public research, in all the countries, you have less and less funding for breeding activities. So it's why we created this in 91 convention, this farm safe seed exemption, and clearly APSA said in the last position paper that we are in favor of the implementation of this farm safe seed exemption. And to conclude on that, we have really the feeling in the Standing Committee on IPR of APSA that this position was not wrong, and it is fitted to the reality of the seed market in ASEAN Pacific area. And we did recently a survey on 7 countries. We ask more, but we receive the clear and detailed answers of 7 countries regarding the place of farm safe seed in the country, the position of in quantity of this farm safe seed. We question also, is there any big selling of farm safe seeds? And at the end of the day, even some of these countries which have a lot of farms have seeds in some crop, it's you have very rarely sale of these seeds by farmers. And this is also important to put in consideration that the restriction on sale, which is a restriction which is debated at the international treaty. You saw in the presentation of Mr. Kumar that some countries like India continue to ask this possibility for farmers to sell seeds of protected varieties. At the end of the day, it's not for farmers. The one who are doing piracy of seeds in APAC, they exist, but they are not farmers. And they are mainly sailors or people who have nothing to do with the seed production and the seed multiplication. And so definitely there is no reason to accept any selling of by farmers or anybody of varieties which are protected without the authorization of the owner of this variety. Thank you very much.
Thank you, Francois, for explaining the farmers' rights and the breeders' rights. So we have, I think, less threat perception from the farmers as compared to some of the other players, which are more threat to the IP position of the breeders. So, do you have any question to Francois for a balance between farmers' rights and the breeders' rights as it stands today? So if not, then we move to the farmer perspective. Our next speaker is Ronaldo. He's from the farmer side, and Ronaldo is having he has been involved in the development work way back in 1981 as early days as Extension Service Officer of Xavier University. Until 91, he studied agriculture in the same university and majoring in development communication from 76 to 80. So he was also agrarian reform provincial coordinator for the tripartite partnership for agrarian reform and rural development project with the NGO Fildhara. Later, he also joined the cooperative movement, jointly organizing farmer cooperatives in northern Mindanao. And at one point, he was sitting at the Regional Cooperative Development Council. Presently, he is chairperson of the Regional Agri-Fishery Council of Northern Mindanao, in Component Board, the Philippine Maize Federation, and president of S4Net Philippines. Please, Ronaldo.
Good afternoon. Hello.
Good afternoon.
Anyway, before I start with my presentation, this is forward. I came here with a mindset, the privilege to be able to share the perspective of the farmers. Big segment in a way, our network in the Philippines. I had all my mind set on it. Then I heard all the inputs from this morning until the latest inputs, and I said, oh my goodness. Well, I proceed with my presentation. Many things I discovered because this is our first time. And before I forget, I'd like to thank the organizers for the privilege of being here. I hope we'll be able to engage in a fruitful conversation anyway. I'd like to go to my presentation. So I'll be presenting the title and then introduction because this is our first time. I may have to introduce a bit about our organization. And then the scenario, I'm putting there limited view because we have not really made a comprehensive evaluation or assessment. Then the learnings and what is important is the way forward. So this is the title of my presentation. Since this is also my first time, I'd like to run through a bit about myself. I grew up in what do you call that thing? Under the coconut industry, the small farmers. Then through a scholarship, I was able to land on a university in Mindanao. Later on, I got my own farm. I'm trying to fast track it because I think the time is like limited. There, that's not my farm. It's the one on top. But this I got a good view. So a little bit about myself. It was mentioned kanina. And then later I was with the cooperatives. I think cooperatives in the third world countries are quite known. And then later on, I was involved in some international fora. And then this is what ASPARNet came about, no? We already about 15 or 20 years, that 2003 we started. And then it was in the Philippines where we had a local ASPARNet, we call the ASPARNet PH. This is about ASPARNet. And this is what at the very start was what we wanted to do as an organization. Responsible farming policies towards improving the quality of life and the environment. So I would like just to line up and run through it. Institutional development, networking. We're part of the Alliance for Science, and we made efforts to be recognized mainstream internationally. But we kept our mass base with the regions, 16 regions of the Philippines. Just part of our advocacies before. BT eggplant, if some of you are familiar with it, it was a struggle in the Philippines, highly politicized. One of the things that we do within our network is we strive to build leaders, no? So we have exercises and we have seminars, which we call our capacity building efforts. And we continuously make forums to update the consultative process. Here, we would like to highlight our visit to Vietnam before they decided to adopt GM. We had consultation and we have groups of farmers, which we call our pool of speakers. So lately, when the COVID cooled down, so we're allowed to make meetings. We went the last 3 months, we came back with our activities. We had roundtable discussions on agri-biotechnology, which we did in the 3 major islands of the Philippines. Okay, the Philippine scenario. I'm just highlighting the 3 crops that are now GM. The first one that we had way back 2002, 2003 was corn. Now, this year, we have incoming BT eggplant, the one that we fought for. And then we now have golden rice. I'm just highlighting here the hectareage and the production because these are also reflective of the potential of these crops being adopted, that will be adopted, at least the 2 of them, in the Philippines. So I'd like to go on to the meat of my presentation. GM was started in 2003. It has been a seed of choice by our growers. But lately, in growing significant numbers, patronage of illegal unregistered seeds by growers, mostly in the island of Mindanao. Primary reason was the spiraling cost of seeds, which led to local initiatives to produce alternative source of planting materials. So the underlying issue here, this is done through the consultations that I said before. The perception, presently corn, is the eventual control of seeds by big industry players, usually the multinational corporations. If I may explain, some of our leaders during our consultations, they highlighted, yeah, we fought for BT eggplant. Yeah, we're fighting for golden rice. Some of them are so advanced, I think, what if this, when the seeds finally come out, it will be with the big players. So we were suggesting in every consultation that we attend that we have cooperatives under the network. Now we have big organization, medium organization involved in seed production within our network. Why not tap these organizations in rolling out these GM crops? Hopefully, something will happen within the next 6 months. So the role of local breeders, I interviewed also a local breeder. They said many of them will end up with the big companies because they're more productive there, there's support, and of course, they're being given the remuneration that they think they deserve. So this one, we're trying to do something about this, the low level of understanding, and thus little appreciation of the inherent value of research. In many slides that, many presentations that I made in the regions, I always emphasize that we should be grateful to the researchers. And I have a slide that I always show up is how wheat came out. It was not wheat when it was there before. It was a combination of, I think, 3 herbs or plants before wheat came out. I always joke, you would not be eating your sliced bread in the morning were it not for the researchers, because there was no wheat in the first place. We have a lot of breeders, correct me if I am wrong, but there was no wheat that when it started. It was a result of breeding, right? Was I wrong? It's correct? Yeah, thank you. So I always reiterate that we should be grateful with the researchers. Intellectual property rights in by the industry. This one has been discussed this morning. Now it's being discussed. The last speaker discussed about this. It seemingly, when I made these slides, collides with the perceived and primordial, say, traditional right of farmers to produce and conserve their own seed. And a friend of mine told me the perspective here is that was way back when we didn't have professional breeders. No, slowly we save the good seeds until all through the cycle we come up with the better seeds, right? And it is being done scientifically now. That's why we have professional breeders. From us, during the many activities that we had, we recognized already the problem of illegal seeds. In fact, that was way back 2018 that we passed in one of our, because we do congresses. We have 3 big islands in the Philippines. We do a congress on the biggest island of Luzon, the second biggest island of Mindanao, and another for the Visayas cluster of islands. We make congresses where we discuss issues and pass resolutions. This is one of the outputs. And we continually do that to update ourselves of issues and the perceptions and the sentiments of our farmer leaders. Like this slide, look at this. I took these shots 3 days ago. And if I'm not wrong, have been having discussions. There was a presentation about how we secure the seeds. But on the ground, I just went through the city where I came from. Sort of said I'll canvass the seeds before the next planting season. And what did I see? You have Sige seeds, the one in repacked. We have, I don't know whether are these registered seeds. So what's happening? No? So there are several arguments to this matter. What we believe as a network is that seed regulations should be upheld, because you know, we have been working with scientists. We invite them in our forums and they explain to us the consequences of being responsible when it comes to stewardship of these noble products. There, observations, learnings. Look at that. Primary sentiment has always been high cost of certified GM seeds. Generic seeds cost 1,800 to 2,500. The branded seeds cost 5,200 to 5,000. That's typographical, to 5,800. The 100 that should be 5,800. So imagine the discrepancy. See? Of those who patronize the illegal seeds, at some point observe low purity, you know. Our compounds were actually stunted or being even killed by the herbicide. And what they do is they shift crop. In Mindanao alone, almost half of the corn area shifted to other crops because of the high price of seeds, at least 30%. High, not only seeds, but of course, fertilizers. So there is a reduction of plant due to high cost of inputs, as I have said. Above instances point more to the need to exert further effort towards farmers' involvement in addressing the issues to their organizations, local governments, local industry players, to strengthen IEC engagement combined with mutually agreed concessions to encourage institutional participation and wider farmer support in every region. Way forward, while the consultations was truly limited, it has involved key leaders in Visayas and Mindanao. No? I am, as of the moment, the chairperson for Northern Mindanao, which is Region 10. We have 16 regions, and we convene every quarter and we discuss again about agriculture and what concerns our farmers. Hopefully, a more comprehensive consultation series involving our farmer leaders can be conducted, not only to elicit more reference, but to also enhance farmers' understanding on the concept of seed certification, its nuances, and the role of farmers play in the preservation of these noble crops. So recent developments on the online selling. Now in the red circle, it is already specified. Counterfeit GM seeds that are sold without the mandatory biosafety permits issued by the BPI, those are illegal or not permitted. Also lately, we had last October 18, our National Agri-Biotech Farmers Congress, we passed this resolution. I'm not really sure if this because the perspective that we were discussing this, I did not have the inputs that I got today, because this is my first time to attend a conversation like this. The perspective that we had was based on the inputs that we had during the October 18 discussion. Congress Resolution number 3, series of 2022, on the issue of fake or unregistered seeds, to urge the Department of Agriculture and the seed industry to share an agreed economic threshold level in the commercialization of GM crops to establish mutually acceptable profit margins and thus possibly address, if not find practical measures that sustain an equitable business environment, both supplier and user benefits in the transaction, and for government to meanwhile provide a stopgap subsidy measure to arrest the spiraling cost of inputs with additional subsidy specific for certified seeds. So this was our latest move on the issue of unregistered illegal seeds. So under the current landscape, current world crisis scenario has compounded the factors that challenges the present price structure of certified seeds. With the country still reeling from COVID-19, the unlikely resolution of the Ukraine crisis in the near future, things are likely to get worse. Declining hectareage planted to GM seems to be the early indicators. The Google culture likewise has encouraged enterprising farmers to seek supplementary options, seeing no immediate redress is at hand for their grievances. They learn to experiment. Example, one advanced farmer leader said, we can always vaccinate the corn so that they will be herbicide resistant. We don't have to buy the herbicide resistant corn. We vaccinate the corn, so later on they will be, as they mutate, I think the technical term there is mutate, they will be also resistant to herbicides. So I don't know the implications in that in terms of the technicality of research, and as probably the breeders know that you have the science, but that was the experience. So they learned to experiment. ASPARNet, if I may state, is the leading national level organized group of farmer leaders that has consistently since 2019, 2012, supported GM technology. We are against seed piracy. We are in the Philippines and we have a wide base of farmer leaders. So I would like to emphasize on the term sustained advocacy. The belief is that the ultimate goal of our engagement is to sustain the presence of farmer leaders who have sufficient knowledge and belief on agri-biotechnology as one of the best tools in improving agricultural productivity and are willing to stand up and defend the concept in any available platform or venue. Our network is spread all over the 16 regions of the country. They would not only be our gatekeepers, but also our force multipliers in the advocacy for good agriculture, specifically on the subject of ag biotech, GM stewardship included, anchored on the concept of farmers' informed choice. So yeah, I'm just acknowledging the sources. And if you want to know more about ASPARNet, we have an FB page where we have featured our prior activities in our advocacy as a network in the Philippines. Daghang salamat. And this has been our byline. Share the bounty of agri-biotechnology through mutual coexistence and responsible stewardship. Daghang salamat. Thank you very much.
Thank you, Ronaldo. I think you get the perspective of farmer. The farmer has choices, and we respect the choices of farmers. And we also see that the farmer wants technologies, want to get the good seed. That's what I said. Farmer is never resolved to the illegal or other things. We have other players, so we have to distinguish between the farmer and the other non-existing actors in this area. Any question to Ronaldo?
Hi, I'm Anke van den Hurk from Planten, the Dutch Seed Association. Can you hear me?
Yeah, the speaker is going there, so.
Oh, okay, sorry. I can speak a bit louder if that helps. Very interesting, your story, and I saw that you had been participating in some discussions in FAO. Would you be interested also to discuss in FAO like farmers' rights? Are you involved in those discussions on farmers' rights?
Not specifically discussed as farmers' right, but it comes as a consequence of our discussion as we move forward looking for ways to improve the livelihood of our farmer leaders. But if there is such a forum or a discussion, we are very interested to join.
Okay, I think it would be useful maybe after the meeting that we have a chat and see how we talk about it after that talk. Great.
We'll be very interested.
Thank you very much for your presentation. At the beginning of your presentation, you said there is still two concerns of farmers. The first one is to say that there will be a risk for local breeders to disappear or to be in the hands of a big player. And the second one was about the fact that farmers still continue to think that there will be no authorization for them to do their own seeds if there is some breeding protection or more breeders. So my question is how we may, what we may do as APSA, as a seed association in Asia, to convince that farmers that they may continue to do their own seeds, at least if it's not my variety. And secondly, to convince also that plant breeders' rights, in a way, is the better way to support local breeders. It's better than the government in a way.
Okay, on the first point, I mentioned that support for local breeders because in one of my consultations, there is a premise that if the government supports the local breeders, they become entrepreneurs and they develop their own lines. And these lines, and under a free market, will, I don't know if it's the proper term, so like it's a competition. So the price can't go up too much because there are local suppliers who also have quality varieties. Because if there are no local suppliers or local developers, and all the developers are now being hired by the big players, so there is some sort, this is in one of our discussions in a consultation, kind of a monopoly, because only the big players, and if they agree among themselves that this is our price range, then what happens to us? So that was the line of thinking when I mentioned that support. And the second one, I did not hear clearly because as I've said, the speakers are going there. So I didn't hear the second point. Not that I did not understand it that much.
Mainly, it's what we may do as APSA to convince the farmers about the fact that we have no intention to forbid their traditional production.
Yeah, about that, as I've said, as I've said, I was actually asking one of our sponsors saying, what is our minimum expectation for this forum? I said, maybe not too high. What is important is we are being able to express as a network. We will not say that we represent all the farmers in the Philippines, but we represent a big segment if you're talking of those who support modern technologies. So looking forward will be engaging, probably not at the international level, but like in the Philippines, we have Crop Life Philippines. I think for Asia, we have CropLife Asia. We have been talking actually with industry, but this was more specifically on understanding and appreciating biotechnology in general, because there are issues about biotechnology and on the pipeline, and we support the industry to push for those that are on the pipeline. Now, in the case of in the Philippines, we have corn, and upcoming is BT eggplant and golden rice. Sometimes the issue is, yeah, we like the technology, we want to plan it, but it has to be affordable for us. So somewhere along the way, we need to later on cascading discussions so that we will understand that it's really worth it. Like, for example, I had the privilege of going to the US way back 2012, USDA sponsored. I was able to go to Iowa, the Corn Belt, and that's where I said, what are we doing farming here in the Philippines? Our farm cannot even house the tractors and the harvesters that the US farmers are having. Why are we farming our 3 hectares, 1.5 hectares? Although lately we have approaches to consolidate. But the realization that there is a big potential and we are nowhere near it, but it also inspired us. And when we visited one of the big players' facility that is processing the seeds, I said, wow, you need a lot of money, a lot of investment. And I realized, yeah, that's why the seeds are expensive. So I think there are strategies that could be possible for our farmer leaders specifically to realize the value of the investment and maybe identify along the way. This is the price from, let's say, the multinational corporation or the big player. This is the price in the counter when we buy the seeds. Somewhere along the way, there's a disconnect. Somebody is making money. So I don't know, it will be part of the intervention or it will be part of the way of the IEC to make the farmers understand and to help them find ways to bridge that gap. I don't know. I don't know the industry secrets, so to speak. This is the price here, and the price here is different, and the discrepancy is quite wide. So we like the product. Please give us a reason to like it more by giving us a price that we can both agree. I think that's the point.
Thank you, Ronaldo. Thank you. I think your suggestions are there. Well, sector will certainly respond to it. We know that there are certain elements which really force farmers to go for illegal seed. And I think that is a question which we will surely answer to the from our stakeholders, that we should be rational. We should be reacting to the situations in a country where these things should not be encouraged. Thank you very much, Ronaldo. Now we have the next speaker. Mr. Manabu Suzuki, who will speak on role of the UPOF system in providing benefits to the farmers. Mr. Manabu Suzuki joined the UPOF office.
Yes. Hello.
Yeah. You are here?
Yes. Can you hear me?
Yes, we can hear you.
Okay. Greeting from Geneva. Thank you, and thank you, under chair introduction. And I would like to try to present my screen. And then and thank you so much, and the organizer, to invite me to present the title topics, role of the UPOF system in providing benefits to farmers. It's my honor to present the benefits of the role of the UPOF system benefits farmers. Even though I am connecting from Geneva, it's a pity, but thank you so much for the organizer to give me an opportunity to provide their representation. And thanks so much, and the APSA to supporting that and recognizing that the UPOF 91 convention is the best PBP system. And then thank you so much for the supporting bodies. And I'd like to present and some of the example that the UPOF system is providing the benefits of UPOF benefits to farmers. Could you make sure I am correct? I'm presenting correctly.
Yes, please.
Hello. Yes. Okay. Thank you. Okay. So let me begin with the mission of the UPOF, which is to provide and promote effective system of plant variety protection with the aim of encouraging development of new varieties of plants for the benefits of society. So it is not only for the breeders, farmers, as a whole, the benefits of society, the mission of the UPOF. Let me begin with the providing an example of the new plant. What is the new plant variety, improved varieties for farmers? And we have the interesting survey conducted by the World Farmers Organization (WFA) last year, which is on the farmers' needs and expectations on new improved plant varieties. As the survey shows that very interesting that the new improved plant variety is important for farmers. As you can see, over 70% of the responding farmers reply that the new improved plant variety on their farmers is very important. And also more than 70% of the farmers felt the improved plant varieties were important for the success of their farming. And also it's very interesting to see that they feel in relation to the responding to the climate change. And more than 8% to 80% of those farmers say that new plant varieties were important in responding to climate change. And also, again, 80% of the farmers and the respondents, they consider that new improved plant varieties is important for the sustainability of the food system as a whole. And I would like to give you some example, more specific example on the UPOF system in relation to the productivity in agriculture in the country. The study, there is a study, we had a study on the Vietnam, the social economic benefits of UPOF membership in Vietnam, and which shows that the productivity and environment benefits of UPOF membership by comparing agriculture before and after the UPOF membership. And then, as you can see, in 1995 to 2005, before the UPOF membership in Vietnam, increased yield were mainly through the increase of the level of input, fertilizer, and pesticides. However, after the becoming UPOF in 10 years period, yield in rice and maize increased annually by 1.7% to 2.5% respectively, thanks to the plant breeding. In terms of the other impact, the economic impact in the Vietnam after joining the UPOF, and have brought annual value and value addition in arable farming by 2.3 billions, and then the horticulture of 1.0 billion, and the total overall impact from plant breeding activity, the investment on GDP has been around $5 billion, which is more than 2.5% of national GDP of Vietnam. So introduction with the UPOF PVP system brought a huge positive impact on economic in Vietnam as a whole. And the Vietnam and shows that, and the study shows that also the income Vietnam farmers, farmers Vietnam increased after UPOF membership, and by 24%, which was induced by plant breeding success, not by the input of the fertilizer. And this is some of the example of what other PVP system, UPOF PVP system gives their access by farmers to access the new plant varieties. The plant breeders' rights application made in those ASEAN countries, we see that the Vietnam, as you can see, there is a huge increase in the in terms of the number of applications the plant breeders' right, which Vietnam became UPOF member 2006. And the other countries are not UPOF member. You can see not a significant increase, rather we even decline the trend. So this graph clearly shows that the farmers in Vietnam get access to the new plant varieties, quality plant varieties, because more PVP plant breeders' right application means more new quality variety that farmers can access. And in case of the Vietnam, the information that from the Vietnam demonstrates the UPOF system has triggered the development of professional production and distribution system of new plant variety, which did not exist before the introduction of the PVP. The introduction of the PVP provides an opportunity for breeders to authorize the seed company and then to produce high quality variety, and they can distribute to the farmers. This the improved environment enables farmers to get seeds and also service. So that's under the professional distribution system environment was nurtured based on the PVP system. This is a kind of the good example technology transfer from public breeders to private sector. Hello. Here. Yes, then let me continue. The following example is that's related to the impact of plant breeders in European Union. And that study shows that without the plant breedings and farmers in the European Union countries would be able worse off by 30% and put under rural environment at risk. The other example is Kenya. Kenya is now one of the breeding exporters in cut flowers, especially for rose. And then the development of the cut flower industry in Kenya has helped improve livelihood of the farmers. Why? It is that estimated that the floriculture industry employs over 150,000 people directly and more than 500,000 indirectly who supply the goods and service. So and Kenya became UPOF member in 1999. Since then, after the UPOF, and Kenya observed increased number of range of the improved new plant varieties became available for farmers. So this is because that breeders are confident they can get their rights protected and get their investment back. And the other example is Peru. The Peru became a UPOF member recently 10 years ago. And in that time more than 80 new plant new varieties of grapes are registered, granted, and export value increased to more than 5 million US dollar, increased in 10 years, 8.8 more than 8 fold. And also for blueberry, more than 16 new varieties have been protected. And significantly, we see over the past only 5 years, the increase in blueberry production was 10-fold, even in only 5 times alone. So this helped the significant change in Peru exports, fresh fruits, blueberry, and they have gone beyond $1 billion of the export value, and which there is about the 13-fold times in the last 5 years alone. The other an example is that UC Davis, which uses the PBP, a system to achieve maximize the public good, which supports the California agriculture. And it achieves that by protecting the varieties, the breeders are able to provide fast access to the new varieties to California growers, and also to achieve income from royalties in other parts of the country and the rest of the world to support the breeding of the new variety suitable for the those farmers, growers in California. So because of the fees and licensing strawberry varieties going back to the UC Davis, which we use for the support the research and the innovation for to develop further the new varieties. And then it's very interesting to see that the US Davis only releases its varieties in UPOF member territories. All the applications are in UPOF members. The other example is that the PVPs and in an agriculture research council, public sector of the South Africa, by protecting their varieties. The Agriculture Research Council of the South Africa were able to set terms where the private sector can commercialize some of the citrus variety with the condition that the license can require that participation by smallholder produce the production of the citrus. And as you are required, the UPOF 1991 Act has the exception to the breeder's right, and there's the compulsory breeder exception to the breeder's right, which is private and non-commercial purpose. And in relation to the small farmers holders of this exception to the breeder's right, the UPOF 91 compulsory exemption, there acts possibility to falling within the scope is that propagation of the variety by farmers exclusively for the production of food crop to be consumed entirely by farmers. It depends on the farmers living in the holding. And we are now have the discussion in the UPOF that to discuss and understand the situation, and then they provide the guidance on concerning smallholder farmers in relation to the private and non-commercial use. And there is the misunderstanding the UPOF system is always big, multiple company, and farmers are prosecuted as an infringement their plant protection varieties. However, UPOF have made a survey, and then found that no example of persecuting of smallholder farmers for infringements of the plant breeders' rights have been identified in any of the UPOF members. And then you have the 99 UPOF Act has an optional the exempt farmer said seed. And as you can see, and this is on the UPOF provision that provides that the party may restrict breeders' right in order to permit farmers to use the product of the harvest obtained on their own farm from the protein variety for the purpose for the propagating purpose on their own farm within the reasonable limit subject to the safeguarding limited interest of breeders. And this the reasonable limits and safeguarding the legitimate interest of breeders is to be considered by national level. This is important for the country to consider those factors, for example, type of variety, size of home, holding, and the crop value remuneration to the breeders. And also it requires the review time to time to reflect the development of the agriculture sector and UPOF members. And there is some of very interesting example in again in Vietnam that of the benefits of the protection rice variety in Vietnam comparing the protected varieties, non-protected varieties in case of rice. And protected seeds certainly are more expensive than unprotected seeds. However, as you can see, the farmers can observe the significant increase in yields by choosing protected seeds. In that case, and the yield increase and almost around 50% was observed thanks to the better productivity. So for farmers, it is worth to choosing the investment the plant variety seeds. So the take-home message is the UPOF system provides more choice for farmers. So this is the good benefits of the farmers in the UPOF system. And this is a last slide. That's the new improved varieties. As I explained, I illustrated some example that contribute to the food security, climate change, economic exports, also environment, sustainable production, and also technology transfer in the countries, which is all farmer benefits for farmers, and that is also the benefits of society. So thank you, for listening. I'd like to stop my presentation. Thank you.
Thank you, Mr. Suzuki. You have explained well the role of UPOF and the protected varieties improve the life of the farmers and their benefit. Are you available for questions?
Sure. Yeah, hear me?
Yeah, we can hear you.
Okay. Okay.
Any question to Mr. Suzuki?
I cannot see that.
Yes, please.
Good evening, sir. My name is Aslim Bari, and I am from Pakistan. You know that in the last 4 to 5 years, Pakistan is a country which is mostly affected by the climate change. And the last year, this situation is very representative of this one, that our most of the crop and the cotton and others. And I don't know if the OPOV is working in a collaboration with Pakistan or for the development of new varieties in especially in cotton and other vegetable crops. So my question is that, is there any collaboration of OPEP in the Pakistan is going on for to meet this climate change and to develop new varieties or not, sir? Thank you.
Mr. Suzuki, have you heard the
Yes.
question?
Yes, thank you for the question. But I cannot see the questioner. But thank you for the question. And then thank you for the question, because as I explained that the UPOF system support, it is a basis of to provide the countries to the, how do you say it, and encourage the plant breeding activities for the benefits of societies. And then as I'd like to mention that the UPOF system is for the UPOF members. So I think it's under Pakistan is not a member, but they think that we can provide information as much as possible for those countries that are interested in becoming a UPOF. And then if we have there you can see that if there are the country become the UPOF, and there is the cooperation between the UPOF members, then they have the very nice experience, and also they have their provided cooperation within their the UPOF members. So I think that it's very good to have the country become the UPOF member. Then we will see the cooperation in relation to their for example, to provide the better improved varieties on cotton to mitigate and adapt the impact of the climate change. I'm not sure that I can answer to the questions.
I just want to know that, sir, as you know that we are from the platform of Seed Association of Pakistan, and what efforts should be made to become a member of OPOP? So can I deliver it to at the government level, or if you want, we can involve our government level, like a federal seed certification department, or the facility from. We have to call our Ministry of Agriculture to contact you, or like someone. So, sir, believe my words. At this time, the international community need a lot of efforts to support Pakistan in the agriculture, because we are the most affected country in the climate change, which is not due to us, sir. Because you know that, sir, we are not the responsible for this climate change, but we are being affected with climate change, which is enforced on us, sir. Thank you.
Thank you, sir. Thank you for the interest of the to the population. I would like to explain that briefly on the procedure to become a UPOF members. Under the UPOF convention, it is required for the country to draft and establish the plant breeder protection law in accordance with the UPOF convention 1991 Act. And so for that, if there is the request from the country to assist to us, the UPOF office, to provide the information or the guidance on how the UPOF PPP system, PPP laws we are drafted in accordance with 1991 Act. We are happy to help to provide the information. For that, it is important for the country in the national level to discuss with whether the UPOF, the country would like to become a UPOF member. So I think that those for the discussion in the national level, it is important to see what the country would like to have your the agriculture and horticulture in the future. And I think that's under the voice from the plant breeders association in the national level, in the regional level, is very important for the country's national policy makers to encourage, to discuss, and to become UPOF membership. And then if there is the positive the decision made by the UPOF in regard concerning the PVP law drafted established by the country, then the country can be able to evolve members. So I think that in short, consultation in a national level, maybe you are the right person to be involved. That's for the discussion national level whether the PPP law in line with the UPOP system is benefits for farmers in national level. Thank you.
Thank you, Mr. Suzuki. I think we have one question from my side that what is the balance of, the definition of smallholder farmers between the treaty and the UPOV? Any shift in the UPOV explanatory notes on that, that the smallholder farmers, not in terms of the land holding or some other things?
And thank you, Chair, for the questions. And it's very important topics that we have now take the discussion in the UPOV level as well. And there is several the position, the definition, the opinion in the members of the union. And then, but as I explained in the before, we have already under frequent question, and that's for the how do you say, the subsistence farmers to exchanging the seeds for only for the to be used for the consumption, and that could be another example. Could be considered as an exemption under the private and non-commercial exemption under the UPOV convention. However, but there is a discussion going on, then maybe we need to see the other development in the future.
Thank you. Any more questions? Thank you, Mr. Suzuki. Thank you for coming and spending time with us. Thank you very much coming online.
Thank you so much, and thank you for inviting me. My pleasure. Thank you so much.
Thank you. So now have the last presentation from Mr. Fabrice. He's presenting on freedom to operate strategies, how to conduct plant varieties clearance search prior to R&D and commercial activities. Fabrice is the global patent head and partner with the intellectual property law firm Rouse. He has over 20 years experience in patent and plant variety protection in Asia. He also has extensive experience in drafting contracts. He's a member of the standing committee before the European Patent Office and the consultant to the World Intellectual Property Organization, WIPO, on biodiversity. Fabrice is also the researcher on climate science at the University of Edinburgh. Fabrice, please.
Great. Thank you very much, Dr. Arwin. And I'm aware I'm the last speaker, so I will try my best to keep you awake, but at the same time aware of the time limits. So basically, today's presentation is about freedom to operate, which may sound to be quite an intimidating term, maybe to some of you. I think I would like to reflect on what I've heard in the last, couple of hours, that it seemed that in the seed industry, we create some level of tension or want to avoid the tension between farmers and breeders, which is great. But to be honest, in my day-to-day practice as a patent attorney, I don't have conflict between breeders and farmers. I have litigation between breeders. That's where most of the IP litigation happen. And when I see all the time we spend on convention, discussing this and that, I think it's great to have a level of understanding between farmers and breeders. But once again, the need for legal tools, system, enforcement mechanism is when breeders fight against each other. So today's presentation will focus more on the interaction between breeders than actually breeders and farmers. So what is FTO? Well, it's freedom to operate. It's pretty simple. It's basically when a company who has some intention to launch a product on the market wants to know whether that product will actually infringe someone else's product. This is a good practice in most breeders' company because they don't want to end up to be sued by a competitor. It's quite different from what we call the patent search, which focus more on the prior art. So in other words, we have, for instance, a client who come to our office and they want to know whether their plant or their process for, let's say, a gene modification can be patentable. They want to know the prior art. So FTO in that respect is different. Why companies are doing that? There are many reasons why plant breeders are interested about FTO. I mean, I won't go through all of them, but the big one is to ensure that they won't be sued by another breeder. Another one is to show their good faith. So if eventually they get sued by a breeder, they can always argue, yeah, but we pay that patent firm, those patent lawyers, and they done the search for us. So we acted in a good faith, in a compliant manner. And it's good for the insurance claims, because if you get sued as a breeder and you've done your FTO, you can tell the insurers, well, now you cover the risk and you pay for the lawyer fees in this patent dispute, for instance. The interesting, I don't know, it's a bit like scientific, bit confusing drawing, but I will try to explain to you. There are 4 possible outcomes when we do freedom to operate for breeders. So the first one on the left side is basically the best one, best scenario. So for instance, the second patent does not infringe the first patent. As you can see, it's outside the claims of the first patent. And my client, who is the owner of the second patent, can therefore manufacture the product or the process. Great, everybody's happy. Second situation is a bit different. My client, which is in blue, can still produce his product. However, his patent will be invalid because it is within the scope of the previous patent. And then the situation number 3 is getting worse. My client will infringe the red patents, but his patent is still valid. And that sounds maybe confusing to you, but there are many situations where that happens. And finally, this is a nightmare for the clients. In blue color, you can see his patent is invalidated and he's within the claim of the other patent. So this is a very simple way of simplifying the 4 scenarios. But once again, you can see we're not having farmers here and breeders here. We are breeders here and breeders here, right? Next, what are the strategies? I mean, breeders not happy when I tell them as a patent attorney, sorry, you can't make that product because there is a prior patent. So legal solution, R&D solution, business solution, it depends. Some clients do have appetite for risk. They will say, okay, never mind, we go for it. We're going to launch this product and let them sue us. Some clients are more conservative. They will say, well, can we actually cancel their patents? And that's something I want to reflect a little bit through one example. I was involved as a patent attorney in this case a couple of years ago in Thailand. There is, and I've heard that in the last couple of hours, a complete wrong assumption that plant variety and patents are necessarily true and enforceable and valid forever. My job as a patent attorney is to kill patents and plant variety. I'm paid for that. My client tells me this patent is not new, cancel it. This plant variety is not new, is not distinguishable. Attack it. So I give you this example. It's quite unique because it's a litigation between 2 Japanese companies, and we have some Japanese representative here, and they know that this is unusual. Japanese company rarely litigate, especially outside of Japan. I was lucky, they litigated in Thailand and they called for my help. So I represented Asahi Glass against Hoya. Now, the patent of Hoya is about the glass substrates. I'm not sure any of you is in physics, but glass substrate must be very, very polished. You know, they use in industry like the semiconductor. I mean, all of you do have actually those substrate in your mobile phone. And they are data recording medium. So there should be no deformation at all on the glass substrate. It's like a CD. You don't want on the CD any deformation. That's the patent of Hoya. The whole thing about Hoya is that they say our invention is to make glass substrate super smooth. And this is a claim on the left side. And they sued my client, Asahi, because my client was making glass substrate of the same smoothness or ratio of smoothness. And I asked a simple question to my client. I say, hey, in your industry, in the semiconductor industry, isn't it normal that we all want super smooth glass substrate? And they say, yeah, of course, we don't want glass substrate with huge deformation. So I say, well, the patent of Hoya, therefore, is not inventive. There is no inventive step. They just do something that the industry really aim to achieve. So we cancel the patent of Hoya and we succeeded. So at the end of the day, again, patents like plant variety are not necessarily made to survive cancellation actions. Remember. So what does the FTO landscape look like? This is an example of a document. So we normally list all the patents that we found as problematic, and we give to the client some assessments, whether that patent is very problematic, that one we can deal with it, that one we can argue, and so on. Now, very quickly, for the next 5-10 minutes, I'm going to explain to you how to conduct an FTO. I do not recommend you to do it by yourself. Having patent attorneys are better source of services, but here, you know, some indication how to maybe work with patent firms when doing it. The first thing is you need to have a very clear understanding of what you are searching for by identifying the keywords, what the technology, is your product, is your process, or is your product by process, all of that need to be clearly identified. Then after that, you have the what we call the patent classification. So it's a bit technical, but when you apply for patents, you have specific classes. You need to know which classes you are searching for other patents. And then you can do supplementary research that I usually recommend to my clients is to look at who are the competitors, because some competitors may be patenting actually more than you do, and you want to know what the portfolio of those patents are. And then, you know, you need to do updates because the world of patent is not static. Patents are being applied, then published, then granted, then canceled, then expiring. It's a sort of mutation, continuous mutation, right? So it's not because you do an FTO in 2020 that the FTO is valid in 2022. So this is basically a flow chart that's being more or less what I just mentioned. It takes about a month to do an FTO if it's complicated. We can do it quicker, but of course, the faster, the less opportunity we have to really go through the documents in details. And that's the big part of the work, is what we call the deconstruction process. So basically, if a client comes to see us for an FTO on a particular germplasm or genetic resource, we will look at the sequence, at the genotype, try to fragment it as much as possible, identify the vectors, markers, all of that, and then start doing the FTO on each individual element. So you can see the colors have a particular, we say, meaning when we link them to the other patterns or plant variety we may identify. Looking at the database, it's always very challenging because even though you have strong and reliable database in some regions, In some other countries, sometimes the database are not updated regularly, so you can't do a very accurate freedom to operate. But here are some examples. Remember that for plant variety, there is no global, I would say, database. You need to go through sometimes regional, sometimes UPOV one, but also local database. But this is basically an important comparison when we do FTO for germplasm that may attract patents, but also plant variety. Remember that the plant variety protection is much longer in some countries than the patent. Patent is usually 20 years, but plant variety protection may be much longer than that. So the starting point of your FTO must consider how far you want to go in order to assessing the prior art. And then when you finish your FTO, this is the sort of mapping you're doing. On the left side, you have the genotype, the sequence with specific colors that we match with the patents or plant variety protection registration that we identify during the search. So we can tell our client for this particular vector or particular gene element, we identify these patents or these plant variety. And then the job of the attorney is to, at the end, make a complete assessment and say, this is the risk factor or risk element you have. So I wanted to make a quick comparison. You know, it's an easy one, but it's memorable at least. The big challenge when you identify prior arts is to conclude whether you infringe them or not. And that's the job of the patent attorney. So there is a principle in patents, which is called the literal infringement. So in other words, your product may be identical to the patents in order to infringe that patents. Okay. So you can see in the example here, there is no cheese in the second burger, so it does not infringe the first burger. Easy. But there is also a principle which is in force in US, in Europe, in Asia, which is called the doctrine of equivalence. So your product does not need to be exactly the same as the one in the patents to infringe the patents. As long as it can be equivalent, that will still infringe. So you can see here, there is no cheese as such, but there is a dressing which may have the taste of the cheese, and that will qualify as an infringement, right? So take the example now for plant variety. It's exactly the same thinking. You may have the same genotype. Okay, that's clear, is an infringement. Now, if the genotype is not clearly distinguishable from the one which is protected from plant variety, it may still be an infringement. So you have the equivalence as well in plant variety, the same thinking as for patents. So that is the end of my presentation. I'm very happy to take on any questions, Dr. Arwin.
Thank you, Fabrice. Thank you.
Thank you.
Any question to Fabrice? I have one for you.
Sure.
What about, I see if there is a scope of claim is too big for a patent, where, you know, that sometimes people go overboard to protect the farthest part of the research, which is not relevant. So whether that patent, if it is challenged, will be valid, or scope can be clipped?
Yeah, I mean, it's a great question. I mean, the vague claims is quite common because sometimes the applicant does not know when you apply for the patent exactly what he wants to claim. So he used quite broad claims. We can definitely attack those claims, and we do that. First, we say those claims are not supported by the rest of the patents, by the description, and is a ground for cancellation. We can also say that there is no unity between the claims. So it's a bit of legal principle, but basically in a patent, there must be unity. You cannot have too many inventions in one patent. You must have one patent only, one invention only, sorry. So broad claims usually bring the risk of having multiple inventions in one patent, and you can cancel those patents on this basis. And the last thing is, I love broad claims because I can cancel easily by bringing prior art. I can say, well, if you claim the world, I can find many prior use, prior arts to cancel your claim. So we love broad claims actually as a patent litigator.
And second thing, what about the native genes? Because there are many countries, the native genes get patented. But native genes, the native genes, the genes which exist in the plants.
Yes.
But in many verdicts that they are challenged and discarded, and still there are patent on the native genes or the DNA segments we call it. So they are discovery code and not the it's not non-obvious, it is obvious.
Yes.
So what do you think about it?
I did not hear well your question because they do echo.
Okay.
Can you repeat it?
So I said there is a native gene patenting. So many genes still get patented, but many genes they get challenged, and the verdicts are against them.
Yes, no, absolutely. I mean, that's something also easy to challenge, I would say. Those patents, I would say, most on the ground of not even the inventive step or novelty, just on the ground of patentability conditions.
BRAC 1 and BRAC 2 is one of the examples by Myriad
Yes.
Genetics. Yeah.
Correct.
Okay.
Thank you very much.
Thank you very much,
Thank you very
members.
Thank you.
So now I have to conclude because my co-chair disappeared from this place. So I don't know where he has gone, but let me conclude the conference on IP. And today we have discussed about the access and benefit sharing, where the speakers really have contributed a lot that in different countries, how the access is being considered and how the benefits are being considered. And then we move to the farmers' rights. We also saw farmers how they are supporting the new technologies and how they are liking the new technology for contribution. And then we took the legal view and also the UPO view. So I think overall in Asia, what this committee wants to do is to really explain our members who are not so savvy to the intellectual property issues. So my co-chair is here, and partly I have done his job, so he will do the rest.
Congratulations to do my job. I'm really sorry, but I had a call of a French journalist who was in the position to finish an article about intellectual property rights and why the intellectual property rights are decreasing the biodiversity. So I prefer to answer him. No, just to say, because I hear you did a good summary. Just to say that, again, APSA from the beginning is very dedicated to this question of intellectual property rights and this question on genetic resources, because we thought in APSA that it's very important that all our members, all our seed associations are really aware about what are the risk for sometimes for the seed industry or the profitability of evolution of regulations. It's why we organize many events in the past. It's why we participate a lot in all the occasion of increasing awareness regarding the interest of intellectual property rights. And I want to say to the members that next April, we decided to organize for the National Seed Association, member of APSA, a workshop which will be again working on the subject that we addressed at the first session, which is about the implementation of international treaty on genetic resources, and secondly, the talk we had already about the implementation of breeders' rights in the region. So thank you very much for your attendance. And maybe I think it's time for some appreciation things.
Yes, so thank you very much, the chair and co-chair. May I invite all speakers to come up on the stage to receive a small token from our chair and co-chair. So may I invite Dr. Shivendra Bajal, Dr. Lorna Iradora, Mr. Eiji Hatano, Mr. Reynaldo Cabanal, and Mr. Fabrice Mate. Please.
So see you next year.
Thank you very much, everyone. It's a long day for today. So tomorrow we'll have one last session for the technical session on Standing Committee for Seed Technology. So 9 o'clock tomorrow. Have a good dinner and have a good evening, everyone. Thank you. น้องมองกล้องด้วย